and start off by acknowledging that this university sits on the land that has traditional custodians who have always acknowledged their ownership and responsibility for the land, and I'd like to pay my respects to them as we commence this meeting. I also need to make two personal notes to begin with. The first is to say that being here today is of personal importance to me. One of my very close friends in Australia came to Australia as a migrant with his family 25 years ago, soon after he left school here in Durban. And for 25 years, I've heard about those years of his here in this city, going to school and the nature of this area. So coming here is a very personal thing for me, and I want to state that at the very beginning. And the second thing I want to state is to make a confession. I'm a fraud. I'm not an academic. I've been a human rights law practitioner for around about 40 years, 45 years. And I look at the law that we'll be discussing today from the perspective not as an academic or an academic expert, but as a practitioner. And so what I want to talk about today are matters that are my perspective on what's happening and what we're doing and my understanding of law. And I look forward very much to hearing the real experts talk during the course of the panels that we will have today. Those who have studied these areas far more intensively than I have and bring the particular expertise of academic experts to this area of study. So I'm looking forward to hearing from you. And as much as anything, what I would like to do in my comments now is to raise questions that can be the subject of our discussions during the course of the day and subsequently, because there are many questions and many perspectives that I've got that you may or may not agree with. Sun has given an overview of the nature of our Commission of Inquiry. And for the purposes of today's symposium, I think it's those accountability areas that Sun described that are most relevant. We have jurisdiction under our terms of reference, the mandate given us by the Human Rights Council, to deal with international human rights law, international humanitarian law, and international criminal law. And in doing so, we rely on the expression of that law through treaties, obviously human rights and humanitarian law treaties, but also other treaties that have human rights as their subject matter or as a critical dimension, such as the Genocide Convention and the Rome Statute. And secondly, we rely on international customary law, and that has important implications for the Israel-Palestine conflict because many aspects of human rights or humanitarian law have not been ratified or accepted by the State of Israel, including the Rome Statute. And some of the Palestinian armed groups are clearly armed groups, not a state, and so not subject to treaty law, or at least not ratifiers or acceders to treaty law. So both the treaty law and the customary law dimensions are important to us and our work. My principal focus is the International Court of Justice, as my title suggests. The International Court of Justice, the principal judicial body in the United Nations system, established by the Charter with a statute of its own in addition, currently has before it two cases dealing with the Israel-Palestine conflict, reflecting the two different types of jurisdiction that the ICJ has. The first case comes out of the advisory jurisdiction of the court, and the second case comes out of the contested case-based jurisdiction of the court. As Sun has mentioned, in December 2022, The General Assembly of the United Nations referred to the International Court of Justice questions dealing with some aspects of the Israel-Palestine conflict. That referral came directly as a result of the work of our Commission of Inquiry. In our report to the General Assembly in October 2022, our first report to the General Assembly, we discussed our views on the lawfulness or otherwise of the occupation that has occurred since 1967. And having examined the nature of the occupation and the law governing occupation, we came to the conclusion that the occupation was now unlawful. We didn't address the issue of whether it had been unlawful from the start in 1967. We could have done that, but we decided that our focus would be on the contemporary situation and the contemporary question of the lawfulness of occupation now. We looked at the facts and we looked at the law and we came to the conclusion that it was unlawful. And so we made a recommendation to the General Assembly in our report that this issue be addressed. We think we're pretty good, but we accept the fact that the International Court of Justice is better than us, or at least is more authoritative than us. We came to the conclusion that it was unlawful, but we wanted the highest court in the United Nations system to address that issue. That's why we made the recommendation, not that we were in doubt, but because we wanted higher authority. We thought that, given the nature of the United Nations, in 50 or 100 years, the General Assembly might take up that recommendation. We were very surprised, therefore, that it did so within 6 weeks. And the General Assembly accepted our recommendation and referred to the court the questions that we wanted referred. Firstly, whether or not the occupation is lawful, and secondly, if it is unlawful, then what are the obligations of third states, that is, states other than Israel and Palestine, and indeed of the United Nations system as a whole, in relation to a finding of unlawfulness? We were trying to expand the question to look at what is the responsibility of others to do something about an occupation that could be found to be unlawful. We were very pleased when the General Assembly made that referral, and even more pleased that it was done by an overwhelming majority of the General Assembly. There was a small number of states that opposed the referral, a larger number that abstained, but a majority that supported it. I have to confess to having been quite confused about the principal argument against the referral. That principal argument was that the referral of this question to the court would undermine the peace process, and that these issues should be left for negotiation and resolution between the parties. Now, I found that surprising on 3 grounds. Firstly, what peace process? Secondly, there hadn't even been the semblance of a peace process for the better part of 25 years. And thirdly, the fact that it could be asserted that every issue concerning the dispute between Israel and Palestine was open to negotiations. What is the role of international law if every issue can be negotiated? For me and for us, we saw the referral to the International Court of Justice as being helpful to the peace process when it is finally revived, because it is a means by which some floor can be set below which the parties cannot go in their negotiation process. You know, are we seriously saying that the negotiation process can result in the elimination of the rights of the Palestinian people, or for that matter, of the people of Israel? If everything were open to negotiation, that would be the case. We saw it as immensely helpful to any resolution and to any negotiations to have the highest court say This is the line which you cannot go below. These are the basic ingredients that the law requires of any peace process. So, to me, to say that a referral to the highest court in the international system would undermine the peace process and get in the way of the negotiations was the complete distortion of the role of international law and the role of the court. We were pleased when the referral was made. We were pleased that the court has started acting on it already. It was significant to us that 57 states or groups of states have made submissions to the court as part of the advisory opinion process. States have the capacity to do that. In addition to individual states, the court has accepted submissions from a number of groups of states, including the Organisation of Islamic Cooperation and the League of Arab States. So these are positive signs, and so far as I'm aware, 57 submissions represents the highest number of submissions on any advisory opinion that the court has been asked to deliver. So in itself, a reflection of genuine and legitimate international interest in the matters before the court. The court also receives documents from the United Nations. The UN's Office of Legal Affairs is responsible for the gathering of these documents, and it has submitted to the court something like 4,000 documents. This has been a matter of international interest for a long time. And those documents include the reports submitted by our Commission. We don't have the standing to make direct submissions to the court, but our reports have been there as part of the UN collection. And in addition, we decided that we would give the court the benefit of our views if they were interested by publishing our views on our own website, so that we have the opportunity to say to the world, but particularly to the court, how we understand the situation. There will be public oral submissions commencing on the 19th of February, which is very soon. It's now thought that they may take 2 weeks or more. Last we heard, in addition to those 57 written submissions, there are 77 states that have sought to make oral submissions to the court. Again, an indicator of the extent to which this process is seen as important in the international system and is seen as a legitimate matter of international concern. Our hope is, and it's only a hope, our hope is that the court will deliver its advisory opinion by the end of this year. The court currently has a very heavy workload by the standards of the International Court of Justice. Something like 200 matters are pending before, 22 matters are pending before it at the moment. And the court's practice is that all judges sit. So that means 15 permanent judges who will be sitting on the advisory opinion. And in the case of cases, you can have ad hoc judges to be appointed by states that do not have a judge on the court, which is why there are 17 judges on the South African genocide case. So it has to fit in with the timetable of the court. All those judges will be involved in it. These things do take time. I know all that, but this is urgent. And we hope very much that we will have the court's advisory opinion before the end of the year. We are concerned ourselves with the second of the two questions for our future work. We've already looked at our views on the lawfulness or otherwise of occupation. We do intend to turn to the question of the implications of the current occupation for third states and the UN. We've deferred that since the court is looking at it, but we want to be ready to deal with that in greater specificity when the court has given its opinion. So that's the first one. The second situation before the court comes under the case jurisdiction of the court, a contested case between states. Advisory opinions, I should say, are advisory. They're not binding. Opinions in cases, however, are. They are binding decisions of the court, which the court itself cannot directly enforce, but for which enforcement becomes a responsibility of the Security Council, with all its problems. there'd been discussion in many areas over the last few months about whether a case can be mounted under the Genocide Convention. Perhaps the main spur for that has been another case currently before the court, that is Gambia against Myanmar, also under the Genocide Convention. That case started in late 2019, 2020, I think it was 2020 finally, and has been winding its way through the court, but has provided a number of important precedents that are being called on in the current case between South Africa and Israel under the Genocide Convention. I should say in passing, I was a commissioner on the Human Rights Council's fact-finding mission on Myanmar, a similar body to this body, our Commission of Inquiry on Israel and Palestine. Slightly different name, same powers and functions. So I was involved similarly in the investigative lead-up work that has produced the Myanmar case before the court. That case does provide important precedents, including in relation to the indication of provisional measures, as they're called. That is, the orders that the court made last Friday to deal with the matter on an interim basis. Dealing with the Genocide Convention is a very difficult task. I said I'm not an academic. I haven't looked at it academically. I'm certainly not a judge like Navi, who has played an enormously significant role in understanding the application of the Genocide Convention in real-life situations as head of the Rwanda Tribunal. But I have looked at genocide now for the third time in a human rights investigative sense. So I've seen the difficulties with the Genocide Convention and its application and enforcement in very practical circumstances. The first was when I was Australian Human Rights Commissioner, and our commission undertook an examination of the separation of Indigenous children from their families. Practices followed in Australia for almost a century. And after a great deal of fact-finding, evidence gathering, and then analysis, we came to the conclusion that that practice was genocidal. One of the keys in making that finding was that the purposes of the governments and administrators throughout the century of this practice of removal were very clearly stated. They made no bones about the fact that the removal of the children and the placing of them in non-Indigenous families was part of the process of the dying out of Australian Indigenous people. A process that was founded on social Darwinism, that Indigenous people were uncivilised and therefore inferior, and they would inevitably be displaced, not just physically in relation to land, but genetically and demographically by the majority non-Indigenous population. It was all very clearly stated from way back in the 1930s as to what the purpose of these policies were. So in that case, we had the smoking gun. We actually had the clear statement of policy made by political leaders and by those charged with the implementation of policy. The second time I was involved in this question was in the Myanmar fact-finding mission. There, it was more difficult because we didn't have the smoking gun of purpose. I should have said earlier that these difficulties are very much associated with the second intent, or the dolus specialis with genocide. You're not only required to prove that intention to do the absolute acts, one of those 5 categories of genocidal act. In addition, it's necessary to prove that those acts were undertaken for a genocidal purpose. That is, to destroy in whole or in part the members of a protected group, the group protected and defined by nationality, religion, ethnicity. So that part of it is the difficult part, finding the special purpose and establishing it. We had the smoking gun of clear statements in the examination of the removal of children. In the case of Myanmar, we didn't. We had a lot of inflammatory material on Facebook, but there were no clear statements from the military leadership or the political leadership at the time. It seemed to us, however, that we could draw conclusions from the way in which the events, the clearance operation of the Rohingya had occurred in late 2017, early 2018. Again, a problem. Circumstantial evidence is fine, but the courts have held that the circumstantial evidence must be such that genocide is the only reasonable purpose. Not a purpose, not any purpose, or one of the reasonable purposes, but the only one. They must basically exclude other possibilities. And that's where the difficulty arises when we deal with circumstances. Were it not for clear public statements made by Israel's political and military leaders in relation to what has happened in Gaza since the 7th of October, I think it would have been very hard at this point to establish genocide. There is what could be a smoking gun, and that is what they themselves have said, including the President, the Prime Minister, the Defence Minister, the head of the military. There are many more junior and less relevant officials who have made statements that could be considered to be the encouragement of genocide or the expression of a genocidal purpose. But key figures have been making these statements. In many respects, the challenge in this case therefore moves from the difficulty of genocidal intent to connecting it causally to the actions that have occurred in Gaza. That is, that these statements have been implemented in practice and not just rhetorically expressions of opinion. So that's one of the challenges that will come later in the piece. So genocide is difficult to prove. We have seen that in courts, but there is much evidence there. And that is why I individually was pleased that South Africa commenced this case. This is a matter that is clearly within the jurisdiction of the International Court of Justice. Some of the arguments mounted by the State of Israel in fact are contrary to the findings of the court in the Myanmar case only 3 or 4 years ago. The court in the Myanmar case found that Gambia had standing, even though it was not directly suffered injury as a result of the alleged genocide. It said that the Genocide Convention was an obligation erga omnes, and that Gambia could take the case. That has been applied again in respect of South Africa in the current case. The court found in that case that orders could be made on a provisional basis to address the question of significant risk, and it made orders. In many respects, the orders made last Friday were expectable, I think, on the basis of what happened in the Myanmar case. But let me come to that later. I want to make some specific comments on the orders that were made. Let me go back to the fact that South Africa was justified in taking the case, and I am firmly of that view. There are facts that are known. Certainly, that enormous numbers of people that have been killed. The fact that now most of Gaza has been subjected to either evacuation orders or clearance operations by the Israeli military. The 16-year siege that has been intensified. There are enough facts there to raise questions. And in addition to that, you've got the statements that are being made by the political and military leaders. You know, in the face of those facts, state parties to the Genocide Convention not only are entitled to bring an action before the International Court of Justice, I would argue that they have an obligation to do so, because the Genocide Convention says that all state parties are obliged to act to prevent genocide and to address a significant risk of the occurrence of genocide. So what are the other, whatever it is, 150-something state parties doing in the face of facts that give rise to a suggestion that genocide may be taking place? So South Africa was justified. It was entitled to do it. It had an obligation to do something. And doing this was within its right as a sovereign state. It seems to me that the objections that are made to South Africa taking this case, the criticism that has been mounted, is not really legal criticism, but ideological, political, and emotional criticism. I mean, ideological because there are some states and some organisations that are so committed to the Israeli government that they will not brook any criticism whatsoever. Political, because these events are occurring in a broad geopolitical space where other states are making decisions that are sometimes confusing or confounding even. You know, one contrast I see all the time that I can't understand is that when trade routes through the Red Sea were threatened, within a matter of days we had a multi-party military action to protect the trade routes. And yet after 120 days we have no international action to protect 2.3 million people. That's confounding. But it's politics, and so politics is another reason for the criticism of South Africa. And the third reason is emotional. You know, let's acknowledge the fact that the Genocide Convention arose most specifically from the slaughter of 6 million Jews in Europe during World War II. You know, we cannot move away from, we cannot deny the reality of the genocide that occurred in Europe, the Holocaust, the Shoah, whatever you want to call it, and its continuing impact, certainly on the Jewish people, but also globally. And the Genocide Convention is not restricted to that one experience, but it is intimately connected to a determination to prevent those things happening again. So they're the major objections to South Africa taking the case. Ideological, political, and emotional, not legal. Can I add a personal comment, though? South Africa would be in a much stronger position, ideologically, politically, and emotionally, if it were more consistent. You know, the rest of us remember when the then South African government allowed the then President of Sudan, al-Bashir, to leave this country, even though he was under an arrest warrant from the International Criminal Court. And the rest of us know that just before the oral presentations in the ICJ on Palestine and Israel, the Sudanese warlord Dagalo was here, being feted. And he is the person considered to be responsible for a genocide in Darfur 20 years ago. So I can't criticise those who criticise South Africa for its inconsistency, and your situation would be much stronger if we saw more consistency in respect for and implementation of international law. But that does not take away from the fact that in this case, South Africa has done the right thing. I told Son I always talk too long, I'm sorry, but I do want to refer to the provisional measures ordered last Friday and make some comments and raise some questions which I would dearly love to hear more about later, particularly from Max. Remember, I'm a practitioner, I'm not an academic, and I look at these provisional orders in a practical sense. The first thing to be said is that the orders are almost identical in most respects to the provisional orders made in relation to Myanmar. So the court was working on that Myanmar precedent again, but the court has failed to recognise that there is an absolutely fundamental difference between the facts at the time of the Myanmar orders and the facts now. The Myanmar orders were made well after the event of the Rohingya clearance operation 2017-2018. By the time they were looking at these orders in 2020, the operation itself had been completed, and although the Rohingya who remain in Myanmar continue to be persecuted, the level of persecution was not such as to give rise to a sense of continuing genocide. And so the orders needed to be preventive, that is, addressing future genocide and the risk of future genocide. In the case of Israel and Palestine, the allegation is that the genocide is continuing, is now taking place and continuing on a daily basis. So the orders needed to be directed towards stopping alleged genocide rather than simply preventing the risk or minimising the risk of genocide. And I don't think the court, in making these orders, has taken into account that the basis of South Africa's case at the moment is a continuing genocide that needs to be stopped. That distinction, to me, is an important one. But let me look at them. The first one and the second are closely associated, so I'll deal with them together. The first one, the State of Israel shall, in accordance with its obligations under the Genocide Convention, take all measures within its powers to prevent the commission of all acts within the scope of Article 2, in particular, and then listed 4 of the 5 categories of act. And then the second order associated, the State of Israel shall ensure with immediate effect that its military does not commit any acts. That order has been criticised because South Africa asked for a ceasefire and the court didn't order a ceasefire. The question I have is, didn't it? Did it not order a ceasefire? It doesn't use the word ceasefire. One reason why I ask the question rather than state a conclusion is that the court is not clear in its statement of what it means by acts under Article 2 of the Convention. There are 5 categories of acts under Article 2 which constitute the actus reus, the act part of genocide. Those 5 acts are there. Is the court referring to anything that undertakes, that does those 5 acts? Or is it incorporating into its order with the purpose of committing genocide? Now, I don't think that's clear, but it has very different implications. If the court is saying that Israel must take all measures within its powers to prevent the acts alone, that includes the act of killing, which sounds to me like a ceasefire. Is the court really saying that we only want prevention of acts that are committed with genocidal intent, and if you're not doing it with genocidal intent, you can do whatever you want to do? Is that what the court's saying? I start from the assumption that judges are not stupid. I'm sometimes wrong, but that's my starting point. If what Order 1 means is that the court is only prohibiting acts that come within Article 2 and are committed with genocidal intent, it's a stupid order, because that's what the Convention already says. Israel already has an international legal obligation not to commit any of the 5 categories of acts in Article 2 with genocidal intent. Why would the court bother issuing a provisional measure that tells Israel to do what it's already obliged to do? I want to give some intelligence to the judges and say, no, that's not what they intended. They're not just saying that white is white or black is black. They actually mean to add to the legal obligations on the State of Israel by making this order. And if it's a prohibition on the commission of any of the acts or categories of acts under Article 2, to me that really boils down to a ceasefire. So let's have some discussion of that, because it has profound implications to what Israel's obligations are under these provisional measures. Number 3, the State of Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide. Even the judge appointed by the Israeli government, Judge ad hoc Barak, agreed with this. One judge disagreed with everything. And I invite you to read and be entertained by her judgment in the way I was. A prohibition of incitement is very important in the context of what I have already described as the possible smoking gun in the Israel case, the statements that have been made. Incitement doesn't require any action to have occurred after the incitement. It is just about inciting to commit genocide. It's a standalone prohibition in the Genocide Convention and a standalone criminal offence under the Rome Statute. So I think there is strong evidence. I can't come to any conclusions until we've finished our investigations. I think there is strong evidence that a significant number of military and political leaders of Israel have committed incitement to genocide. There is strong evidence to that effect. And that is reflected in the fact that the court has made a specific order, supported by Judge ad hoc Barak, to prevent the incitement to genocide. The next order. The State of Israel shall take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance. This is a humanitarian order, entirely to be supported and praised, but possibly outside the jurisdiction of the court. To be able to make this order, the court has to be able to link the denial of humanitarian aid to genocide, if it's under the Genocide Convention. Part of South Africa's case argued that very strongly, and I think the court was relying on that. But this is not quite as open and shut as may be the case. But there's another dimension of this that concerns me greatly under international humanitarian law that is not being addressed at all. If this order is linked to the Genocide Convention, so is this other issue. The order talks about Israel. Let me give you the direct words. Take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance. Fair enough. But Israel has an international legal obligation not merely to enable the provision by someone else, but to do it itself. It is the occupying power. And under the Fourth Geneva Convention, Israel certainly has a duty to protect the occupied population from violence, but it also has a duty to ensure the survival of the occupied population, consistent with human rights law, by providing food, water, fuel, transport, housing, health, education, and so on. This is an international legal obligation. And I become somewhat confused when I see UNRWA being attacked, when in fact for the last, at least since 1967, UNRWA has been enabling Israel to avoid its international legal obligations. That's what it's been doing, because UNRWA has been providing the services to the Palestinian occupied people that Israel has an obligation to provide. And it's not just a matter of opening the borders of Gaza to enable UNRWA and others to bring in food. Israel, as the occupying power, has an obligation to provide schools for kids, hospitals for sick people, houses for homeless people, food for starving people. the court's missed out on a much greater obligation on the state than the one that it's dealt with. Next, Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence. South Africa rightly asked the court to order that Israel grant access to bodies like ours, the Commission of Inquiry. It didn't mention us by name, but that was the clear intention: international investigative bodies. Israel won't let us into either Israel or the occupied territory. And certainly we would have welcomed that being part of the order. That was not part of the order. It dealt only with the failure to, the need to protect evidence, prevent its destruction and so forth. Same order in the Myanmar case. I think they've just backed up on that, but it's a pity that it didn't go further. And finally, that Israel shall submit a report in 1 month. Here the court did not go as far as in the Myanmar case. In Myanmar, the court has also ordered 6 monthly updates, or 12 monthly updates, I'm sorry, I think it's 12, I made a mistake, from the state of Myanmar in relation to implementation of the provisional orders. The court here has asked for 1 report only within 1 month. I hope this will be an issue that somehow can be addressed in the future, because this case is going to take years, and we need to have a process by which Israel is accountable on a more regular basis than in 1 month's time and at the end of the conduct of the case. One last point only on an order that was not made. I was very interested that right at the end of the decision, the court called for the release of hostages. It didn't make this as an order, because it really can't make orders against Hamas, it seems to me. So it was a call. It's not a call in any way related to the Genocide Convention. This is an issue of international humanitarian law and international human rights law, so clearly outside the jurisdiction of the court. But very interesting that the court included this call in its decision. And I'd love to have been a fly in the room when they were discussing this. Was it done for political reasons? Because they felt they needed to give something to the other side? Was it done for ethical or moral reasons that the court felt compelled to say something as serious as the holding of hostages? It is very serious. It's a crime. Love to know why the court did it, but it sits there at the end of the decision without any real legal jurisdictional basis for being there, it seems to me. I hope you've got other ideas and can help me to know and understand this better. The other interesting thing that I would add as well is that the court's decision includes reference to events and statements that have been made since the oral presentations, or certainly since the originating documents, and then the oral presentations were made. Refers to statements and death tolls and so forth, post the oral arguments. I'm glad they did, but it strikes me as a violation of due process rules. Now, normally, courts take the evidence that's put before them by the parties, and if they've got other things that they want to rely upon, they have to put that to the parties to give the parties an opportunity to respond before the court relies on it. So it was an interesting, dare I say, aberration to see this in the decision, and yeah, that deserves some further thought and discussion as well. So that's it. I've talked too long. I've given my impressions. I can't say they're the impressions of the COI, because Navi and I have had lots of discussions, but we don't have a COI view. But in doing this, I want to echo things that have been said repeatedly. We look for help from the experts, the legal experts, the historians, those who are there on the ground, those who witness things. And we want as much help from you through the panels, through your Q&As, as we can possibly get. But that, at the moment, is how I see it. Thank you.
Ladies and gentlemen, I'd like to thank our esteemed guests for their discussion this morning, and we do have some time to take a few questions from the audience. If you would like to raise your hand if you do have a question for either Commissioner Sidoti or for San Kim, please.
Thanks very much. Try that again. Third time. There we go. Thanks very much to both of you, Sun and Chris. Chris, that was the most cerebral presentation by someone who keeps saying they weren't an academic. So if that was an academic, I'm not sure what is. I want to push you a little bit on your final point. So you rightly say that the order regarding the hostage, or the suggestion about the hostages, is difficult to cognize legally because they are not a party to proceedings, Hamas. Now, one of the reasons we don't have a ceasefire is because the argument was that because only Israel was party to the court, a ceasefire order would be unilateral in effect. But a creative measure would have been to make a binding order on both parties, and right, both Israel and Hamas, all parties involved in the conflict, and on all other parties, including South Africa, to ensure there was a ceasefire. Now, the difficulty we have there is Hamas is not a party, but we've accepted they're a party for the purposes of the hostages. So if we can accept that, surely we should have accepted for the purposes of a ceasefire, we can make that order. And related to that, in the absence of any indication from the court about why they didn't find in favor of the first provisional measures order, what are we to understand about it? So what is lacking from the absence of a concurring judgment, some indication about the questions of self-defense and ceasefire?
Thanks, Chris. I like the first argument. I'll borrow that and use it next time. Just what we need. If I can take it, though, one step further, yes, I think that the argument has been the court cannot make orders against Hamas. But that's not the full story, because, as you say, it can make arguments against other state parties and require all of them to take action. But it can also make orders against the state of Palestine, which is a party. Now, Hamas clearly is operating outside the control of the Palestinian Authority, but that does not mean that the Palestinian Authority has no legal responsibilities in relation to Hamas. And so a ceasefire could be ordered in such a way as Palestine, the respondent to the application, is required to take action. And why not even get a report from them in a month as to what their ideas are about what everybody can do, all the state parties, to bring this genocide to an end. So I think that there were a number of areas of potential that could have been explored but weren't. And I like your one, that if you're calling for the release of hostages, they could also call for a ceasefire by all parties in it. So I didn't understand the second point, Chris. Could you just say that again?
So we don't have an indication from the judges as to what the discussions were. We have some concurring opinions, some dissenting, but are we not, I know we have a big majority, but we're slightly poorer for not having some explanation of the elephant in the room, which is the question of a ceasefire. Sorry,
yes, and I agree 100%. And the same was the case in relation to the Myanmar matter, that the court basically recited, they said this, these said that, these are the criteria, and this is our decision, and there is a gap between 4 and 5. And it would have been enormously helpful if they had done so. Some of the both declarations and dissenting opinions were very interesting and are well worth a read. I was particularly interested in the decision of Judge Sway, who had voted against the provisional measures in the Myanmar case, but voted in favour of the provisional measures in this case. And I was interested in being able to read her reasoning for the change of position. And one of the judges in the majority, Judge Nolte, had a very lengthy and very interesting decision, which did go much more than the formal decision into some of the arguments behind his thinking. So it's well worth reading the declarations and the dissents for the enlightenment that they can provide.
Morning. Thank you very much for this symposium. We really do appreciate it, and also the insight into what's going on with the United Nations. Something which is really confounding for me is that the United Nations, which gave legality to the State of Israel, and as you said yourself, has been the enabling factor for aid to the Gazans, which has been seized for the last 16 years. Why hasn't the United Nations itself taken a stance against what's going on? And per se, United Nations has been an enabling factor to the occupation by not putting an end to it. The world stands by and watches, as it's doing in India currently. We know that they have declared that out of 10, India stands at 8 out of 10 as going on to a genocide as to what's going on. And here we are sitting at the cusp of a similar situation. And the world stands by until we have a situation which is completely untenable. And the whole world is now, rebelling, and still it continues. What kind of world are we living in? I mean, this is unbelievable. People go into a hospital last night and they shoot 3 patients. And it continues. What is the use of the United Nations? What is the use of Human Rights Watch? What is the purpose of the Genocide Act or the Rome Statute? These are all nullified by the powers given to United States and the UK and their allies. People suffer, be it in Sudan, Myanmar, the Muslims in India. We stand by and we watch. People are being killed, literally thrown out of their houses, businesses burned. I mean, the temple that was now built at a cost of $217 million. The land is disputed. There's great facts behind it. It is a mosque. I'm not going to dispute that or argue that today. That's not our purpose here. But the purpose of my point is that we stand by and watch all these acts taking place until an entire community has nothing left of it.
Your questions are questions without answers. One thing I would say is the problem is not failing to take a stand, the problem is failing to do anything about it. The General Assembly has passed resolutions. Even the deadlocked Security Council finally passed a resolution, but nothing is done about it. That's the basic question.
Hi, I'm Nesty here. Just to add to what Munira has said, we see a lot on social media that people are asking for the United Nations to invoke Article 6. Could you speak to that a bit? Because the deadlock decision really rests on one country, and it's an elephant in every room, but it is the United States at the end of the day that is protecting its allies. So does the invoking of Article 6 give civil society and diaspora of Palestinians globally a greater foot to stand on now after this genocide ruling from the ICJ?
I also don't know if I have all the answers to the questions, but I will say that states, as I said earlier, are the architects of our international legal system, and they are the primary duty bearers It is up to states to ensure that all of us can live in a world free from human rights violations, and the important work of civil society, students, lawyers, everybody in this room, it is our job to press our states to act, our politicians, our government officials to take that stand, because we are the state, they represent us. And so I would say in this multilateral system that has many flaws, it's the system that we have. And I don't think we could create the United Nations in 2024. So as flawed as it may seem, it is what we have. And that's why we try to work within it. And I will say that I can only speak on the work of this particular Commission of Inquiry. And the staff is small, but we're mighty. And we've been working very hard since the start of the commission. As Commissioner Sidoti said, have already made reports talking about the long history, the opinion on the legality of the occupation. The Commission has done everything it has been able to do within the mandate given to it on this issue. But I'm sorry I couldn't answer, the bigger questions.
Thank you. Good morning, everybody. My name is Roy Ramdo. I'm a practicing lawyer. Something that worries me is the events of the 7th of October. Now we have you, Commissioner Chris, here, Christopher. You can give us a full understanding. Is it just merely propaganda as to what Hamas did? And regards to that is the doctrine of clean hands, approaching a court. We know the principles that you don't come to court with dirty hands. And then the extent of reasonable self-defense by Israel to what had happened on the 7th of October. Now, these are two concerns of mine with regards to whether we'll succeed with the application we've made at the end of the day at great cost to South Africa. There's a lot of criticism that we can ill afford it. Figures are being punted to almost 2 million rands that will cost us 500,000 for the initial application and 1.5 million by the time we finish the application. And the repercussions of this action to the trade in South Africa. I had a client that called me yesterday, want to move his business out of South Africa. He's in the manufacturing sector because he says he's frightened that he's going to have the repercussions, that he's not going to benefit from the AGOA agreement with America and so forth, because America is a big market for his products. So, we've started something. We like to see it going. I'm a member of NADAL, the National Association of Democratic Lawyers. We're all behind South Africa in this application, but these are some concerns that we need to address. Thank you.
Thank you. I can only respond very briefly to say we started investigating the events of October 7 on October 7. Our investigators are still working. We are confident to provide answers to questions like the ones that you have asked. What actually happened? What does the evidence indicate? We're not in a position to do so yet, so I can't tell you. But our two reports, as Sun has indicated, this year to the Human Rights Council in June, to the General Assembly in October, both of those reports and documents that we will produce in conjunction with those reports will address the findings of our investigation. So I can't indicate anything at this stage until we've actually done the work.
Thank you very much, Commissioner Sidoti, Sun Kim. Thank you very much for your questions. If there are any outstanding questions, we can take them after the next panel session. I would like to take this opportunity to invite you for a short tea break. We will reconvene at 11:30 promptly for the first panel discussion. Thank you.
Sure, I can hear you. Cool.
Okay, we're going to get started in a couple of minutes. We're just waiting for a few more dignitaries to arrive. Okay, good morning, everyone. Welcome on my behalf to the School of Law of the University of KwaZulu-Natal. My name is Christopher Givers. I will be chairing this panel, which is the first of 3 panels that we're going to have in this particular instance, dealing with the diplomatic response to the situation in Gaza, and then later on we'll have one dealing with the international legal response and the humanitarian response. So I'm joined on stage by friends and experts in this particular issue and on the question of international law more generally. So I have with me on my right is Professor Sitembile Mbete from the University of Wits. On my left is Pretoria. First mistake.
And I'm not appropriate.
2 mistakes. I got one more, so let's see if I can get through the rest of this. So on my left is Attila Mangonidze from the Institute for Security Studies. There we go. Getting better. And we have incoming commissioner at the Human Rights Commission, Professor Tsepo Madlangozi, who speaks not as a commissioner as of yet, but as an incoming commissioner. So before we get started, I wanted to introduce someone who couldn't be here, unfortunately, because he's taken away on important government business. So Mr. Zane Dangor is the Director General of International Relations and Cooperations of the Republic of South Africa. Before being appointed to serve in this capacity in April 2022, he was a special advisor to the current and former ministers of international relations and cooperation. Before joining DIRCO, he worked as the Chief Operations Officer of Seoul City. He holds a master's degree in international law and a master's in public and development management, both from the University of Wits, South Africa. And Mr. Dangor has agreed to join us live, so thanks very much. Go ahead, Mr. Dangor.
Okay, thanks. I just lost Chris there for a moment. Can I? Good afternoon, all. I think it's good morning. I just landed, so my apologies for not joining you live. I wish I could have been there. I think it's quite an esteemed panel. And also just to thank the UKZN and Janine Hicks and others for organizing a discussion like this. I think it's important. I was listening to some of the inputs earlier, and maybe just from my side, just wanted to re-emphasize a few things. The reason South Africa took this case through to the ICJ was essentially to stop the killing. When we saw that this was a textbook case of genocide, and our president and others called it a textbook case of genocide, we felt that under Article 1, we were duty-bound to take this then to the institutions of global governance meant to deal with this. So we were a little astounded by the initial criticisms by some that why are we taking the legal route and not the political route. We thought that we needed to take the legal route to stop the killing. And that also informed why we took Article 9 rather than Article 8 as the vehicle for our petition under the Genocide Convention, because we wanted the potential of provisional orders that were binding. So I just wanted to sort of bring that back into the space. Also want to give thanks, I think, at this stage, and one of them is there, Max, I think Duplessis is with you, but to give thanks to an excellent legal team. I think the legal team outlined the facts very, very succinctly. They outlined all the genocidal acts. They outlined intent, and you all know that the special provision of intent has to be present for genocide to be proven. And I think also showed that the messages of intent didn't just land in the ether. The messages of intent by senior leaders of the Israeli government was internalized by the foot soldiers. And these foot soldiers, through videos and their actions, articulated the fact that they know what their message was, and they made reference to Amalek, for example. So in sum, I think that given all of that, we feel that the judgment is good. It's important, if one looks at the judgment and the manner in which the president of the court outlined the judgment, made the case very clearly for the fact that there is a plausible case for genocide, which then gives rise to the fact that these orders were given. Much is being made about there not being a ceasefire. Our application didn't use the word ceasefire, but of course we asked for the end of all the military action that was giving rise to the genocidal harm. And we think we did achieve that. If one looks at the first order combined with the second order, where the first order outlines all the provisions of Article 2 of the Genocide Convention, and then the injunction to the Israeli government to order the IDF to stop all actions that will be in contravention of Article 2. And in combination with all the other provisions, we do not think that the judges did not intend for basically instructing Israel to oblige by its duties to end the harm by its current military means. So I thought that is important for us to bring from a messaging perspective into this discussion and other discussions. Also important, I think, that Israel spent 45 minutes of their own pleadings to talk about self-defense. The judgment noted that this was the defense, but actually did not entertain it beyond that. And in essence, they did not need to, because the 2006 Wall opinion on the issue of self-defense still stands. And so just my concluding remarks for the panel and others is that despite the provisional orders, as one of our lawyers said in her pleadings, this is perhaps the only genocide in history where the people are sort of broadcasting their own destruction. There remains no safe place in Gaza. And we hope that the countries that feel that international law is important and the institutions of global government is important will work with us to ensure that Israel respects the orders of the court, because that can only be in the interest of international law. As we said in some of our pleadings, international law itself may be under the microscope, and we don't want a situation where international law loses the respect of the international community, because the institution of global governance is the tools that small countries like ourselves have in order to ensure that we deal with impunity. We cannot deal with impunity other than the institutions of global governance. So on that note, again, thank you for inviting us to be part of this discussion. It's a pity that I can't be there in person and to engage with all of you, but thank you very much. Thank you, Janine. Over to you. Chris.
Thank you very much, Mr. Dangle. So we have a good chunk of time to discuss, and I thought we might start with a couple of opening remarks from each one of our speakers. And let me start with you, Dr. Mbete. I get that right. So Dr. Mbete, if you can give us a sense of the context. So we heard this morning about this is a test for the global order. I think, as Commissioner Sidoti said, nothing more dramatically exemplifies the sort of rupture in the international order than our Minister of International Relations standing on the steps of the highest principal judicial organ in the UN, and the great powers bombing one of the poorest countries in the world in order to manage the free flow of free trade. So to what extent are we in a unique moment of rupture? And if you can give us a bit of a sense of where does this locate within the broader history of South Africa and Palestine?
Sure, thank you so much, and thank you to UKZN for inviting me to be here. It's a great pleasure and so much fun to be on here with friends and colleagues. I think, so what I'm going to do is I'm going to place this in that context of kind of where we are in terms of global order, and then speak also around South Africa's history of diplomacy on the Palestinian issue, which I think is something that's gotten lost in a lot of the commentary on this particular ICJ case. Look, I think that certainly the last 10 years have seen a decline in US hegemony and an increase in multipolarity in the international system. It's a trend that goes beyond sort of the last 10 years, but I think has been felt quite acutely in the last 8 to 10 years. Certainly since 2022, with Russia's invasion of Ukraine, we saw a revival in kind of Cold War rhetoric about a bipolar world, sort of the West against the rest, and where the West there was sort of the states broadly aligned with US foreign policy, including Europe, Australia, Japan, while the rest was sort of people aligned or behind somehow China and Russia. What we've seen with Gaza is an entrenchment of those opposing sort of responses to Gaza, but also a slight proliferation actually in power, where the countries that are taking the lead in defending Palestinian interests, in making this a big issue on the multilateral stage, aren't any really of the big powers, and the other part of the context is that the international institutions that were established to maintain international peace and security after the Second World War, chief among those the UN Security Council, have proved completely impotent on either mitigating Russian aggression in Ukraine or dealing with the Israeli aggression in Gaza. So the whole question, the whole meaning, and I think we heard this in some of the questions that were raised after the last speakers, the whole meaning of a rules-based international order is in question and is actually beginning to seem kind of nonsensical. And so there is this urgency, I think, of a wholesale transformation of the multilateral system. And these are questions that have been brewing. You know, we were talking yesterday about how our formative experiences of international relations, our coming of age was around the 9/11 and then the Iraq invasion. I remember watching the invasion of Iraq on CNN from like res in my first year at varsity. And so these are questions that have been debated since then, but we've seen them really come to a head since October 7th. And in this context, I think South Africa has been one of the states that has been actively trying to intervene on these issues in different ways through its foreign policy since 1994. South Africa has highlighted constantly the uneven application of international law and called for a rethinking of the contemporary multilateral system. And I think that's mainly a function of South Africa's own history, right? Like the ANC and the PAC being very involved in being observer members of the UN from 1974 and being very involved in advocacy around the issue of apartheid internationally and building up a kind of international front against apartheid, and that's a trend that goes back, to the 1940s. And seeing the potential of the UN as this institution where there is at least theoretical equality of states, and where you can have a rules-based order, the same rules applying to everyone, to protect smaller states from bigger ones, and to really achieve the interests, developmental, security, governance interests of the mass of the world population, not just a few elite states. And so that has been the foundation of South Africa's foreign policy since 1994, and we have seen that repeated in different iterations over time since then. So I want to take from that a move to just looking specifically at South Africa's diplomacy on the Palestinian question since 1994. And here it's to make a political argument, not a legal one, because while I take the argument that was made before about the lack of consistency in South African foreign policy in terms of commitment to international law, I do think that the Israel-Palestine question is the one area where South Africa has been consistent in foreign policy since 1994, has had complete consistency, and I say this as somebody who studied this quite actively for my PhD, that this one area, regardless of administration, regardless of which faction of the ANC is in charge at any given point, where the approach to this question has been consistent the entire time. And let's see, I've got 4 minutes to do this. So if you look from 1994, there were, even on the Oslo Accords consultations, Mandela was one of the leaders who was not involved in the negotiations, but who was consulted and sort of engaged to use his relationship with Arafat to try and, when there were some, hiccups and hurdles along the way, to help with facilitating those negotiations. In 2002, when South Africa first chaired the non-aligned movement, South Africa actually hosted a retreat with leaders of Israel and Palestine of the PLO at Speer in Stellenbosch, of all places. And it was intended to contribute to the Middle East peace process. At the time, it was the first time both sides of the conflict had communicated with each other officially in over a year. And it was the first of, I think, 2 or 3 other dialogues that took place in other fora from there. And basically, it was meant to be sort of a multi-year initiative, but of course that was interrupted by events after that. In South Africa's, and the statement, I think, is worth reading at the time, saying, South Africa has remained consistent in its approach, and due to our own experience of negotiating a comprehensive, just, and lasting peace, has credibility with those Israelis and Palestinians who are genuinely committed to forging their own peace agreement. Of course, we know that that didn't last. And then in South Africa's 3 terms on the UN Security Council, it's been very active in trying to bring the issue of Israel and Palestine in different iterations of the conflict, whether it was over the incursions that were taking place in Gaza in 2009, or 2008, I mean, the phosphorus attacks, South Africa always trying to bring this issue to be discussed seriously by the UN Security Council. And one of the frustrations of South Africa and other similar countries in the Security Council as elected members was how much the Security Council decisions always center around US interests. and US interests being sort of proxy for Israeli interests, and how excluded elected members of the Security Council have been in being able to impact on this. I want to close on something interesting that I noticed as I was preparing for this, actually, was that in both the 2008 term and then in 2011, one of the countries that South Africa engaged with a lot on this issue was Indonesia, and we know that Indonesia has said that they want to bring also a contested case on the occupation to the ICJ. And so many of the countries that are currently taking a lead on these issues are countries that South Africa has been working with on this diplomatically for decades now. And so the idea of interest in this and engagement on this as being something that's like new or fashionable or inconsistent, I think is just factually incorrect, and is quite damaging and belittling, actually, of the actions of not just South Africa, but similar countries, because as we move head first, like a car crash, into a multipolar order, world orders don't change peacefully. They don't change gently. They change through war, through great destruction, and I think we're there. We are at the pinnacle of the change of world order, and it's going to be ugly. There's going to be a lot of death. And I'm not optimistic about the ICJ judgment. I think that there's going to be a full-on genocide of the Palestinian people that is going to be the trigger for the next iteration of the world order. And countries like South Africa, like Gambia, like Indonesia, that have been sort of looked at as sort of upstarts on dealing with some of these things are going to be at the center of creating whatever the world order is that replaces this one in whatever form of the earth that is habitable by humans that we have left.
Thanks, Dr. Mbete, for that rich and sobering analysis of where we find ourselves. And so Prof. Madlungozi, if you can, just picking up, I think, where we left off, if you could give us a sense of where to locate these developments within South Africa's own history of foreign policy post-1994. So we're thinking about different imaginations of the international order, the current one coming to a violent end. What do those imaginations look like within other traditions outside the West?
Good morning. Good morning. It's good to be here. Thank you, Chris. Thank you, Janine. Thank you to colleagues from the UN who invited us. This is a very special moment, and it's a privilege to be amongst friends, colleagues, to reflect on these issues. I want to talk about these issues from a cheesy perspective, you know, from a decolonization perspective. Is this move a decolonial move that South Africa has made? And the short answer is, I think it is. I think, you know, number one, I think, you know, there's no doubt that this very small country, a country without a name, you know, standing up against not Israel, but really we should understand this as standing up against the backers of Israel. Right? That's how we should see it. It's, of course, in the first place, is to, you know, protect Palestinians against Israel. But at the larger level, at the macro level, this case is about a small country standing up against the United States of America, the UK, EU, and so forth. Right? And I think, you know, I just want to talk for 5 minutes maybe. For me, this is an opportunity for South Africa to clarify its foreign policy, right? And it's an opportunity for South Africa to make it clear that its foreign policy is not just based on human rights, unity, peace, prosperity for Africa, and constitutional values, as they say, you know, on their website. but that it is a policy that is anti-imperialist and anti-colonial. You can't have a foreign policy in a multipolar world that is still marred by what Thabo Mbeki called the global apartheid, and your stance is only peace and unity. There needs to be a clear anti-colonial, anti-imperialist policy. So the first point that I want to make is that this is an opportunity for us to clarify our policy and to make it explicit, that is based on anti-imperialism and anti-colonialism, and that is what we are doing. And it's also an opportunity for us to clarify some of the contradictions and inconsistencies, in our policy on this question of, colonialism. So in the first place, colleagues, I've seen a lot of decolonial scholars dismissing the case. International law does not work. International law is a product of colonialism in the first place, but also in the second place, international law can't really be enforced against powerful actors. And so we know that argument. We all know that. This case is not a strategy, but it's a tactic. It is not a strategy, it's a tactic, part of a broader set of tactics to dismantle what we call, the global matrix of coloniality. South Africa has gone through 4 phases in its foreign policy. The first phase, of course, was, the phase of Mr. Mandela, where the aim there was the post-pariah status reintegration, where South Africa was, coming from being a pariah status, trying to reintegrate into the global system. And the second phase, the President Thabo Mbeki's era, which was based on what he called African Renaissance. And that is where we should be returning to. The African Renaissance of Thabo Mbeki as a linchpin of our foreign policy was based on a clear understanding that our mission is not simple to reintegrate into the global system or to make it work, but that our mission is to dismantle it because it is still, as he put it himself, still marred by what he called global apartheid between the global south and the global north. I'll come back to that. The third phase, of course, was under the presidency of Mr. Zuma, which, was marked by confusion, marked by a scaling back of our international engagements, including closing a lot of our embassies, including a exodus of a lot of skilled, diplomats, right? And then now we've got this era. This moment is a moment to really think about, is it time to go back to, the era of Thabo Mbeki, whatever it will look like now, a foreign policy that is based on anti-colonialism and anti-imperialism. But I must say that it is also an opportunity for us to clarify the inconsistencies that Commissioner Chris was talking about. Let me give you one anecdote. In 2002, the Khulumani Support Group instituted a case in New York against 23 multinational companies that aided and abetted apartheid in South Africa. I later joined Khulumani as the national spokesperson. And what was disappointing about that era, where as civil society, as a social movement, we were trying to hold these multinational companies accountable for the crime of apartheid, the crime of humanity. And our own South African state doing something unprecedented, which is that they file, and some people were involved in that in this room, that they file an affidavit in court, which has never been done before, to say the court, please dismiss this case. This case will lead to disinvestment, and this case has been dealt with, before the TRC, which was patently not true, So on the one hand, we, proclaimed this anti-imperialist and anti-colonial, sentiments. But on the other hand, at the local level, we supported some imperialist interests. So the question for me is, as we reform the multipolar world, and I hope it doesn't come to what you said it will come to, or it won't take that. The genocide is already happening anyway. We know that the genocide is happening. So as we do that, what is our mission? Is it simply to rescue the global system? Is it to dismantle it? And where does the question of Palestine lie in that, So for me, that, it's interesting that, this case should be used as an opportunity to clarify and to really reform our foreign policy. Thank you.
Thanks, Prof. So I think that's exactly right, to both situate it in its global context and to remind us of the unfinished business of apartheid and justice for apartheid in South Africa. One of the things that went missing in the hullabaloo last week about the ICJ case was that the Costas 4 case was in court on Monday. The Costas 4 case is the first ever prosecution of a crime of apartheid anywhere in the world. It's the first ever prosecution of a crime against humanity the crime against humanity in South Africa, and it was delayed again for reasons that are beyond explanation, which were that the state hadn't paid for the accused legal bills. So while we are in the International Court of Justice, we have justice at home that remains unfinished. So I thought I would turn to you, Attilia, and ask you, please, to tell us a little bit more about the relationship between South Africa and Israel in its longer context, and perhaps complete the picture.
Right. Thank you so much, Chris. And again, thank you both to UKZN and, of course, our visitors. I say our because Navi, you've come back home, but you've, together with your fellow commissioners, have been doing stellar work, not only now in the context of the occupied Palestinian territories, but then also in other contexts as well, such as in Myanmar. I will say, speaking after, and I regret this, by the way, speaking after Stembile and Tsepo, I feel like, who wants to listen to me? But I'll start by stating the obvious. This, as we're speaking here, it makes it seem as if this is an easy conversation. It's not. What Stembile has said, but also more broadly, reflecting on how much time we can invest a day, maybe more, in intellectualizing from relative comfort. I don't know, the two that have the more comfortable couches can testify, from which we observe what is going on with, I dare say, in the spirit of decoloniality, King George V's statue overlooking the city's rolling hills just in front of us. We talk of winners and losers within a court process, sometimes so much that we actually forget why we are having this conversation. That, of course, as Zane pointed out, millions are living in conditions that a lot of us would not be able to survive in, and others are not living at all because their lives have been exterminated. And so that is always my point of departure when engaging on otherwise intellectual conversations about justice, about diplomacy, about diplomatic ties. It's also worth saying that from my point of view and the view in law, there is no justification for genocide, however you want to cut the cookie. There is no instance in which genocide is justified or justifiable. It does not matter which people are impacted or affected. Those people's lives cannot be exterminated simply because they are those people. So that's where I start. Then I'm going to choose some moments in history and reflecting on the diplomatic ties between South Africa and Israel, but then also taking a step back, ending where Stembile started, around where this all locates itself in the world. My question is whether diplomatic ties between South Africa and Israel were ever normal. I'm not going to start in 1994 because that seems convenient. I'm going to take us back to 1948. In the year 1948, the South African Parliament, if I can be generous in calling it that, made apartheid law. They made it such that what is inherently unjust, inherently corrupt, inherently racist was acceptable in law. In 1948, the place that we now called the occupied territories of Palestine became the occupied territories of Palestine, a continuation, mind, of over 50 years of an attempt to occupy those territories. In 1948, the diplomatic ties between the apartheid state of South Africa and the state of Israel could not have been better. Between 1948 and 1990, for example, starting when other countries started to disinvest from South Africa, the one country among a group of countries that continued to offer support to the apartheid state of South Africa was Israel. So let's not start on the relationship in 1994, but let's use 1994 as a turning point. What changed? What made it such that the Palestinian cause was the South African cause? Maybe let's go to 1997, when Nelson Mandela, may his soul rest in peace, on the International Day of the Solidarity with the Palestinian people, not only reaffirmed his support for Palestinian rights, but stated very clearly, and I'm going to say it 3 times, in case you forget anything I say. We know too well that our freedom is incomplete without the freedom of the Palestinians. We know too well that our freedom is incomplete without the freedom of the Palestinians. We know too well that our freedom is incomplete without the freedom of the Palestinians. It's not just South African freedom that is incomplete. It is a recognition that if there are peoples anywhere in the world who are not free, we can sit, as I say, comfortably on a stage and say we are free, but are we really? If there are people anywhere else in the world that are suffering under a yoke, to borrow Commissioner Madlingo's, as of the 3rd of January's words, free. What about in 2011, when the former Minister of Foreign Affairs of Israel, Tzipi Livni, decided to not travel to South Africa on the possibility that she could be arrested for Operation Cast-Lead? For those of you who do not know, between December and January 2008 into 2009, one of the first bombardments, including white phosphorus in the territory of Gaza, was carried out. Tzipi Livni was, of course, foreign minister at the time. Due to the actions of civil society organizations based here in South Africa, Max, stop smiling, I'm referencing your work, and litigation that called for some form of accountability, that said, yes, South Africa, a country with no name, is so far from Palestine and Israel geographically, but not so much if we go back to the words of Nelson Mandela, should also not be a safe haven for people alleged to have committed, at the time, war crimes, crimes against humanity, against other people. She has since never come to South Africa. An arrest warrant wasn't issued, but the threat of one remains. Maybe we go to 2014, when finally, upon the recognition of Palestine's statehood, even though it's incomplete, there were efforts to ensure a full referral to the International Criminal Court. Or we go to December 2017, when the governing African National Congress voted to downgrade the embassy of South Africa in Israel to a liaison office, followed soon after in May of 2018 by the recall of the ambassador of South Africa to Israel. These are moments in history that speak to a policy position in that relationship. So I will say on the 12th of January, when Counsel for Israel argued that there was no dispute between South Africa and Israel, I thought, surely not. Surely not the country that said we are not free until our freedom is incomplete until that of the Palestinians is recognized. Surely not the country that was seeking an arrest warrant for a foreign minister of Israel. Surely not the country that supported a referral of the situation in Palestine to the International Criminal Court, and certainly not the country that downgraded its embassy. But if your dispute in your mind starts only on the 7th of October, then maybe you will be surprised. But why would you be? when in November of 2023, following an extraordinary summit of BRICS, one that they'd never had before to discuss a peace and security issue, the President of South Africa clearly articulated as the President the view of the state that in fact Israel was committing genocide. But those arguments were already made, and we know that just last week there was a decision on that. So we know what relationship has existed before 1994, we know what relationship has subsisted since, but it's not just about South Africa and Israel, and I know that I've got about 3 minutes left, Chris, to talk about the many other actors often ignored within the context specific to Palestine and Israel, and then I'm going to take us a little bit away from that. Whether it's in Yemen or Qatar or Saudi Arabia or Lebanon or Jordan or Egypt that don't have the convenience of distance to be able to engage in this context, who find themselves also as actors in an ongoing conflict. Whether it's those that are a little bit further away that through their financial and technical support have enabled the continuation of the war, whether it's the deprivation of UNRWA's funding that allows the actual work, and Commissioner Sidoti, you put it so well, that the work that shouldn't be done by a UN agency is being done by a UN agency because the state that has the responsibility to do that work has chosen not to do so. And when some agencies do seek to do their work, as has happened repeatedly over the past 3 months, whether the World Health Organization or the World Food Programme being blocked from accessing territory, or even investigative panels or commissions, some of whom are in this room, are unable to carry out their work because the territory is not open to them. And then you have states seeking to intervene in what we know will be a long, drawn-out process on both sides. States seeking to support South Africa's case, and states seeking to undermine South Africa's case. States that, in the words of the Namibian president, have no business pontificating on genocide. Because if the Nama and the Herero could speak today, they would probably say, we miss some of our ancestors killed in the early 1900s as a test for a genocide yet to come. So, we need to be challenging, as we were told earlier, the notion that we ever had a global world order. I've used global world order in phrasing, and many have done so as well. But maybe if we go all the way back, let's not go too far back, let's go to 1948. Maybe if we reflect on the disorderly nature of what we call a global world order, we can actually start to unpack it, as Commissioner Matlingozi has done. We can start to reflect on the countries excluded from that global world order or forced to be in a global world order by abiding by rules maybe that do not apply to them. But what do we know about the institutions we have in my last minute? We know that institutions like the International Court of Justice, however uneven, unequal, unfair sometimes the system may be, will and can issue judgments that vindicate positions that we hold dearly. We know that without the actions, even sometimes limited, in the Bosnia and Herzegovina versus Serbia and Montenegro case 31 years ago, some of you were not born yet, if they had not then spoke to some of the issues that we're now discussing, we would not have a precedent related to provisional orders in respect of the application of the Genocide Convention. So yes, ICJ judges in January of 2024 can borrow from past decisions because past decisions exist. I would argue that they shouldn't have to. I would argue that we shouldn't have a context in which we say never again, but then for whatever reason, Chris likes to say this, we actually say never, comma, again. I'm going to repeat it again. It's not never again, but it's never over and over and over again. It'll be Bosnia that brings Serbia to the court. It'll be the Gambia that brings Myanmar to the court. It'll be Ukraine that brings Russia to the court. It'll be South Africa that brings Israel to the court, because we're not giving effect to never again. I end, Chris, I'm like 30 seconds over, with stating the elephant that's in the room. We've spoken about the relationship between South Africa and Israel. I've spoken about the many other countries that find themselves in this playing field. And this plays out not only in the context in Palestine, but also in the drawdown of support for countries like Mali, Burkina Faso, and Niger, also in context at the Democratic Republic of the Congo, in Sudan, South Sudan, the Central African Republic. You will note that I'm stating only African countries, not because the rest of the world does not matter, but because I'm African. And we need to be asking ourselves whether international diplomacy in a so-called rules-based order can succeed if we question who is in the dock and who should be in the dock, if the threat of veto continues to compromise the foundation of the UN as a body meant to advance international peace and security, all this talk about diplomacy only matters so much. But tomorrow, for those of you who care, Algeria, following a request to the UN Security Council, will be, of course, arguing on why the ICJ decision that was handed down last week should be enforced. And hopefully there will be no veto then, but sometimes hope is cut short by reality.
Thank you, Atilia. So what we saw there was a masterclass in history from all our three presenters, and a masterclass in the importance of history. And to my international law students, now you know why we spend the first 3 weeks of our course talking about history. So I also wanted to thank you for bringing up the longer history of genocide. I think what's forgotten a bit when people talk about Raphael Lemkin, who coined the term, was that Raphael Lemkin was a bit of a radical himself. And he wrote a history of, before he died in 1959, he wrote a history of genocide, where he set out the history across antiquity, the Middle Ages, and the modern genocides. And the genocide he started with was the Nama and Herero genocide in 1904. So it's very important to hold on to those histories for better, and I think to hold on to them for worse, because the other 1948 moment that I teach about is the Universal Declaration of Human Rights. The father of that was Hirsch Lauterpacht. Hirsch Lauterpacht wrote a document in 1945 called the International Bill of Rights of Man, from which he excluded two groups of people, Black Americans and Black South Africans. And he excluded Black South Africans because he said there was a sui generis case of settler colonialism, and it would be a threat to their Western civilization if they were given the rights in the International Bill of Rights. And in doing so, he cited Jan Smuts. So we have to be very wary of our instruments and their origins, both for better and worse. There's histories we can uncover and histories we need to challenge. And I wanted to shift a bit of gear there to talk a little bit about the present. Right? I've never done this in my life, said that's enough history, but I'm going to say, let's say something about the present, because at different points we picked up on the idea of capacity. Right? So the decapacitation of international relations under President Zuma. We've spoken a bit about this before, and I know your work speaks to this, Sithimbele. So this is undoubtedly the most important international moment we have in South Africa's post-1994 foreign policy. I guess my short question is, are we up to the task? Institutionally, intellectually, politically, can we do what it's going to take to make this the meaningful moment that it otherwise might not be?
Thank you. Look, I think that one of the things that has been displayed in the around this ICJ case in South Africa taking it is that our diagnoses or all the analyses that we give about the failures of state capacity in South Africa, that the weaknesses are not even, right? And that there are still places within the state that have very strong civil servants, but also cultures of civil service that allow for the putting together of a case like this and doing it quite competently. However, I do think that what we can't shy away from also is the interaction between the domestic and the international, and sort of that foreign policy, good foreign policy lies on a solid domestic base or domestic foundation. And so when Tsepo was speaking about kind of the African Renaissance of South Africa and South Africa's internationalism then, a lot of it was based on having a strong economy. And that sort of stayed for quite some time. So in 2007, you could have South Africa pledge $1 million per annum for capacity building and humanitarian assistance in Palestine over 3 years. And also agree with IBSA, India, Brazil, South Africa, to provide an additional $1 million per year from IBSA funds. And South Africa could make those sorts of promises because we were liquid. We had that kind of money to be able to make those sorts of promises and to commit to those sorts of interventions. We no longer are. And so there is a fragility, I think, in terms of the domestic foundation of a lot of these initiatives that we mustn't take for granted. I think also the fact that we're in an election year, and I'm not wearing that hat while I'm sitting here, but whatever the shifts may be at national government level, beyond May, probably, of this year, I think are also something to be aware of about, well, how much will, we've had a foreign policy guided by one party with one particular position on this issue for 30 years. What happens afterwards when or if that position is diluted, I think is something that we are going to need to sort of take stock of. And then a final thing is that I think something that the government does need to be challenged on is that the commitment to the rights and the quality of life of Palestinians, which is incredibly justified and necessary, should also be matched by a commitment to the quality of life and safety of its own citizens, which I think that we can be sometimes in question at different points. And so that domestic foundation of the foreign policy, I do think, is something not to neglect and not to think about. But what we also know, and we're seeing this in the United States, is that states often have foreign policies or project foreign policies in the midst of deep dysfunction domestically around all sorts of things. And I think that, it's an election year in the US as well, and we're going to be seeing a lot of the consequence of that. And so how this dance, I think, between the domestic and the foreign policy dimensions, I think is of course a question that's going to keep playing up.
Thanks so much, Sitambile. So I want to pick up the 2 points and then give them quickly over to our other two panelists. So the first is the question of liquidity. Right, so the elephant in the room, and there's many elephants in the room today. We have a big room, so it should be fine. But the elephant in the room is AGOA, right? Is AGOA. So what are the fiscal consequences, and we will feel them. And so in some sense, these were already coming because of our positions on Ukraine, or they were under threat. But Attilia, can you give us a sense of whether our salaries will come in at the end of the month, or whether we should worry about the fiscal sort of responsibility and condition of South Africa in response to this?
Interesting question. I'm going to take us to a day before the ICJ decision. The Minister for International Relations and Cooperation of South Africa, Naledi Pandor, had a call with the US Secretary of State, Antony Blinken. They primarily focused on Israel and Palestine, reiterating, as people often do, the need to protect civilians, sustain humanitarian assistance, and lasting regional peace, which focuses on a two-state solution as part of that conversation. The end of it, and I'm just going to read it because I was not in that meeting, was that Secretary Blinken and Minister Pandor reaffirmed the importance of the US-South Africa partnership and cooperation on shared priorities, including health, trade, and energy. A lot of the analysis on AGOA, that is the American Growth and Opportunity Act, in which the United States, in partnership with a majority of African countries, have preferential trade terms for those who do not know what AGOA stands for. The last meeting was just a few months ago in Johannesburg, at which, of course, the relationship between the US and South Africa then was already quite terse, and not because of Israel and Palestine, but actually because of Russia and Ukraine. And one of the main commentary at the time was South Africa is going to be thrown out of AGOA. And I remember, against perhaps the tide of a lot of people who thought that, I thought, only if the United States does not need South African products would South Africa be kicked out of AGOA. Now, my end note on this is to say, often pragmatism takes over. Will you be paid at the end of the month? Chris, I'm not your employer. However, what I can say is it is unlikely that this would be the context in which AGOA falls apart, not only for South Africa, but for the other African states that are also party to it. But I think what is important here is a reminder of pragmatism, one, and then the other element around trade, which is, let's be blunt, we exist in this world in a relationship of parasitic symbiosis. Until any of us are self-sufficient enough not to have relationship with other states, we will have relationships with other states. It's no coincidence that the call between Naledi Pandor and Secretary of State Anthony Blinken was on the 25th of January. I've learned in my very short life that there are very few coincidences.
Thank you, Atilia. So if I can come to you, Tsepo, to pick up the second part of Sitambele's reflections, which is on the domestic question, right? So when we think about the idea that the people of Palestine, our freedom is not complete until the people of Palestinians' freedom is complete. Well, a lot of your work is focusing on the question of whether or not our freedom is complete. And freedom, in fact, in South Africa is a question, and a question that we can answer in different ways. So I wonder to what extent, drawing on your work on decolonial thinking and on the question of the freedom of the people of the country currently called South Africa, to what extent are we a warning for the freedom that awaits the people of Palestine? So can we really hold ourselves out as a country that has sort of found that post-colonial moment, or do we have to also teach lessons, not just for better but for worse, about the conditions of freedom and imperialism?
You know, what has been interesting is the mobilization domestically, you know, especially amongst very young people who are not interested in politics. But you go to Bokab in Cape Town, you go to Bloemfontein, they're talking about Palestine, they're talking about geopolitics. That's very, very interesting, right? And they're talking about Israel, you know, in a very unfavorable term, and the United States. So this consciousness raising on decolonization, freedom, and liberation, you know, has been very interesting for me. You know, that, you know, overnight, you've got a lot of young people who are talking politics, who are talking freedom, who are talking Palestine. But what is disappointing is, you know, as we obviously know, you know, there are wars going on in Sudan, there are wars going on in the DRC, and everywhere. And no one is saying anything about that, you know? So that's one part of it. The other part of it is that, you know, yesterday we here refers to the Human Rights Commission. We launched our report on the 2020 unrest that happened in KZN, in KwaZulu-Natal, and in Gauteng, where over 350 people were killed. Much more than that, by the way. But officially, about 350 people were killed. Many more injured for life. That's a lot of people. And in our report, we make it clear that, you know, the cause was not the incarceration of a former head of state, that the cause were poverty, extreme inequality, the trust deficit between the citizen and the state, and so forth. So, and then if you go back a little bit, last year, more than almost 80 people dying in a fire in Johannesburg, in a building, 80 people. You go back a little bit more, life is a Dimeni. You go back a little bit more, Marikana. We can go back, you know. Black life still does not matter in South Africa. Black life is still cheap in South Africa. So, it is true that our freedom is incomplete until the freedom of Palestine, the people of Palestine are free, but we are not free either. Let's be very clear about that. We are not free either. So, to what extent is this moment, you know, my name is Tshepo, so I'm hopeful, you know. I won't tell you what my surname means, but yeah, my name is Tshepo, which is about hope. I'm hopeful that this consciousness raising, especially young people, about the situation in Palestine, will serve as a trigger for them to ask very difficult questions about our state of freedom, especially 30 years into democracy. You know, this year, you are going to see a lot of celebrations, you know, about South African democracy, you know, about South African freedom, you know, and they're born free will be 30 years this year, so they're no longer born free. I mean, they are adults now, they've got kids and so forth, some of them, you know. So hopefully, and we know that this month we are going to see another round of Feast Must Fall, unfortunately, you know, and it might be worse than, you know, the one that took place in 2015 and 2016. So to answer your question, my hope, you know, seeing it domestically, is that this moment will allow us, as we go into the election, for young people to raise difficult questions about what is freedom, what is democracy, what is liberation. You can have a very good constitution, but the material lives of people is getting worse, getting worse. So what does it mean, right? And of course, you know, reactionary people are asking, how much did this cost overseas? You know, how much did this trial, you know, how much did it cost South Africa to litigate? You know, that doesn't matter. You can't put price to freedom. But as Timbile said, you can't be anti-colonial overseas, but domestically you do things differently. Thank you.
So we almost up in terms of our presentations, but we have a good chunk of time for questions. So I thought I might open up the floor to those who want to ask questions or have some hands already. So I'm going to go in order of people who haven't spoken yet. So I think just, and if you don't mind, just shortly introducing yourself when you, if you're comfortable, when you ask the question.
Thank you. My name is Norman Dima, founder of Ndimanomics and researcher. I mainly have comments and a bit of questions, but just comments based on what the three speakers have outlined in their opening. For Dr. Mbede, I like your point where you said there's a decline in the United States hegemony. Do you feel like the Biden administration, given their actions, and which is somewhat contradictory given that they were in support of the democratic dispensation, do you think that the Biden administration is somewhat desperate for the December elections in the United States? Dr. Madlingozi, with regards to your perspective on should we go back to an African renaissance during the Thabo Mbeki era. I think the current president, as you can see, I wouldn't necessarily say he's a Pan-Africanist, but you can see that he is placing himself in the international space in as far as replacing South Africa in the mediatory role in as far as conflict resolution that we've seen in the Ukraine, Russia. You kind of seeing that he's placing, but I would not really say I would label him as a resuscitation of the African Renaissance, given his policy stances locally. In as far as South Africa, you can see that his role in the SADC region is quite soft, if we are to be realistic on that, in comparison to the former President Thabo Mbeki. Former President Zuma, I feel like the less said about that, the better. Ms. Otila, I just want to pose or ponder on what would be, in economics we call it an opportunity cost. Yes, we have a moral ground. Nothing justifies genocide, and I'm not disputing that, but what then becomes the opportunity cost of economic retention vis-a-vis morality in the global sphere, especially looking at the geopolitical tensions that are rising? How would then the heads of states that are typically doing whatever they want, do you feel like the cost of economic power and economic retention is becoming higher than ethics, basically? Yeah. Yes, those are my points. Thank you.
So that's the first time someone's ever said I only have comments and they actually have questions. Normally it's the other way around, but I think those are all wonderful questions, and I actually want to give everyone a chance to respond before they disappear. So.
Sure. Look, I think it's been fascinating watching the Biden administration on this particular issue because there seems to be a lack of awareness of how much, firstly, the Democratic Party has changed in terms of its base and how young people in particular are thinking about things. I saw yesterday the results of a poll that showed that amongst the 18 to 29 demographic, Biden's support or the view on his performance that he was doing a good job, I think was at like 27% or something, which is unheard of for a Democrat president of that demographic in the last 30, 40 years. So it's interesting to see just the disparity or the disjuncture between this administration's approach to Israel and the mood of the party. Young people, Arab Americans, we know that there's a lot that's been happening in Michigan, which is an important state, and so sort of a swing state, and that it seems likely that Biden's going to lose the Arab American vote there. And we've seen also people in the administration leaving and making these big sort of statements about why. And so, yeah, it's going to be interesting. I think that we are going to prepare for President Trump in November, and that's not any better for the Palestinians. I mean, make no mistake, I don't know that that is better. But I do think, in general, Trump is a bigger threat to the United States than he is to Africa and to other parts of the world. And so I think it's going to be a very interesting election, not because of the Democrat-Republican contestation and what happens between the two presidential candidates, but to see how it plays out within the Democratic Party itself, and goes back to this thing of, the domestic politics and how it impacts on kind of international relations and foreign policy. So, so that's what I'm looking at, particularly because then what are the consequences for that going forward for American democratic politics?
Yeah, I mean, before I forget, on the same day that the Secretary Blinken called Minister Pando also took a call from Minister of Iran, on the same issue, so that's very, very interesting, I must say I've been very surprised by our president's position on this issue, pleasantly surprised, He's been very clear. So it is true that South Africa has been consistent, not just South Africa, but the ANC has been very consistent on this issue. But I think we are blessed that at this moment we've got a minister who is very firm, who is very clear, who is very competent. We should say that, our minister, and a DG that is an activist, DG, Brazil, has been very forthright on this issue for a long time, So we've been consistent, but at this historic moment, we were particularly blessed that we had a very clear minister and a very clear DG on this issue. And the president, I've been very surprised that he's been very, very vocal on this issue, very, very clear, Of course, there's some contradiction that as we are doing this, especially on Ukraine and Russia, not clear position, on Russia, not clear people. So we say we are non-aligned, but what does that mean? Do we support the invasion, of Ukraine? What does that mean? Not very clear, but also, sending a high delegation of ministers, a high-powered delegation of ministers to the United States to explain what we are, why do you have to do that, So there's been contradiction, but I think, we've been very, very blessed by, a very, very good Minister of Justice, yeah. Minister of DICO, you know what I mean. And Yuji.
Atilia.
Right, Nomandima, thank you so much for your... in trying to respond, and I'll be quite brief on this, around the opportunity cost of what I'm going to call the opportunity cost of accountability, right? I've heard a lot of comment, public and otherwise, that, we really have no business taking a moral stand in the way that we do because it's going to impact our trade relationships, it's going to impact investment, a whole list of things. So is it worth it financially? Tsepo already responded to that, which is, it's almost as if we do this exercise of tallying rand or tallying dollars in terms of, I suppose, the human cost as well, then we also do a disservice because, and I think, I quoted Nelson Mandela specific on Palestinian cause, but we also know that there are other causes, for example, whether those of the people in Western Sahara or elsewhere in the world where this particular argument has been raised and in which we may think, let me put it bluntly, we may think that this is a problem over there. So we let it go. We allow it to simmer in whatever way or form. And then we see the ripple effects back home in different ways. That's not to say that there shouldn't be a direct and continued investment in a developmental state in South Africa, in the rest of the continent, because we do need that. Inequality is unsustainable. How we rectify inequality and who invests in that process is something that we do need to be interrogating more. What I will end with is that war actually costs more than peace. And I'm not saying this just from a human cost point of view. I literally mean financially, if we're going to talk economics, war, the expenditure on war can far exceed that of education, of healthcare, of access to resources than peace does. The other cost that is often unspoken about of war is the impact on the environment. So beyond food security, the actual direct impact of war on what we experience as climate change. Now, if we de-link these conversations, it becomes, it becomes easier to say, if we don't follow this path, we will prosper. Well, we're not, frankly. There's so many different elements that we need to do to be able to ensure development. And the final thing that I will say is there's very little value in being the only developed or better developed country in a region of underdevelopment. And that's another conversation that we can have, and I don't want to get into that, but it is to say, when we speak about how we need to prosper, we also have to recognize the importance of prosperity of our neighbors, of the rest of the world as well, because we don't want to entrench that inequality and just say, you know what, maybe let's not involve in questions of justice and peace, and then we'll be richer. We won't be richer for it.
Thanks, Atilius. The biggest emitter of carbon in the world is the United States military. And that carbon is not caught in many of our calculations because they won't let us know about it. So we have Thandi. 1 second, Matt.
Thank you so much to this very informative, I think, and quite radical panel, I would say. I don't think it's common that we have these conversations openly, and it is great to be doing this at home. Tsepo, I do have a question about something that we're not speaking enough about, in my view, is the question of identity. And the continuation, you have all spoken about the continuation of the past to the present. Do we maybe see a realignment to the past and how our non-aligned movement was actually a Pan-African solidarity movement that reinforced humanity within all of us? So it really disturbs me when people say, this is going to cost South Africa so much, when Madiba reminded us that it was countries like Cuba, Libya, Palestine that invested resources in the liberation of who we are as people at a time when they too were confronting sanctions, backlash, and enduring the costs of standing up for us. I just wanted to find out from you what you thought about, especially on a youthful continent where, of course, we are highly unequal, we don't have enough connectivity to the world, yet at the same time people are on social media very well connected. What does it speak to us as our collective identity? And where do you think that fits within the context of South Africa, as my grandfather would say, without a name? And what role does identity politics play in reinforcing our division to be weaponized against us? Thank you.
Thanks, Thandi. And just one more question, very patiently at the back.
So I've spoken before. So I'm Nesia Smaram from KZN Palestine Solidarity Forum, and also on social media and a social media activist. Since we're discussing law in South Africa, just to bring it back to our domestic policy, I know that the Department of International Relations did issue in December the thing about the IDF, the South Africans serving in the IDF, and that statement was made. But that statement has been made before in 2016. And given now with social media and access to social media, we see that we have South Africans serving in the IDF, proud to be singing the South African national anthem, and then plundering and murdering and killing babies and harming men, women, and leading to all the issues that we do see in Gaza. So as departing from the ICJ case and on an international stage, why haven't we as a South African in our legal team put in forth the transformative constitutionalism to actually take away citizenship of these people or punish them to the full extent of the law, since they are in contravention of South African law and not international law? And when can we actually see that form of transformative constitutionalism and decolonization happen?
Thank you very much. An excellent question and a wonderful segue to the panel after lunch. But I want to first give Tsepo a chance to respond to Thandi's question.
Thank you for that question, Thandi. I agree with your subtext, which is that, this has been a deconstruction of identity politics. I see a lot of my friends who are in the decolonial movement and also in the Pan-Africanist movement who says we don't want anything to do with the Palestinian question because those Arab are racist against us anyway. Some of us have experienced this when you go to some of these countries, racism, xenophobia, and so forth, So for us to actually say this is a question of freedom of liberation, it doesn't matter who, besides our long-standing question, but to say this is an issue of freedom, it's not a question of that we're just, helping these black people, but that we are supporting, people because they're being oppressed. For me, it's been a very interesting decolonial move, which is not rooted in nativism and in stupid identity politics, So for me, that has been very interesting. You're quite right that, even when our economy was not doing well, Dr. Mbete, we were pledging money for Cuba, for example. And of course, domestic people even went to court to say, you can't do that, we don't have money. But, Cuba suffered so much for our freedom. It's a pity that South Africa is so xenophobic as a country, because even the frontline states in Southern Africa, Zambia, Mozambique, and so forth, lost so much by standing against apartheid South Africa. And we have not, really given back, acknowledged that as a country, as a collective, So really, yeah, from an identity politics perspective, this has been very, very interesting. I hope this will be a re-imagination of the non-aligned movement. We should stop being, a bit radical. We celebrate, commemorate Bandung and so forth, but the non-aligned movement, because of so many contradictory actors within it. But I hope this will be, and the non-aligned movement has not come up very clearly in support of South Africa's case. Some states have, and they issued a statement, but hopefully this will be a going back of that radical, NAM. Thank you.
Thanks, Sipho. Ottilia.
Thanks a lot, Chris. Just specific on your question around revocation of citizenship. Now, only those South Africans who are South African by naturalization, as the current Citizenship Act is framed, can have their citizenship revoked. That is not to say that those South Africans who are citizens not through naturalization, so by birth, by descent, that there aren't other mechanisms which also apply to the naturalized citizens for accountability. There is the Regulation of Foreign Militaries Assistance Act of 1998 and the Prohibition of Mercenary Activities Act, which focuses on activities in third countries at war, that also deal with this question of whether you are a South African citizen by birth, by descent, by naturalization, being part of an armed force, whether of a state or of a military wing that is not of a state, those two acts can be used to prosecute you. What I said in December, and I'll continue to say, is please continue to share your TikToks, continue to share your tweets, because it is on the basis of that people are able to identify the individuals. It's not enough to have a member of the Crimes Against the State unit at the airport waiting for people to land, because what we know is there currently are no direct flights from Israel into South Africa, so most people would have come via a connecting flight. It becomes extremely difficult to identify who is coming from serving as a militant or as a member of another defense force. So the best thing that they can do for us, and I hope they're currently offline, is to continue to share their names, their details, where they're stationed, the crimes that they're committing, because those two acts apply, but also our ability to prosecute crimes against humanity, war crimes, and genocide domestically also apply, beyond just signing up to be in a military when you shouldn't.
And just to add to that those same statutes punish the incitement and the encouragement of people to go and join and fight in a foreign war as well. So the net is very wide. Sitembile, can we give you the last word?
Thank you. I like having the last word. What I do want to say is that it strikes me that something that we haven't spoken about directly, to some extent Ottilia has, but that is the massive elephant in the room, is the system of global extractive capitalism, which is, the political economy that drives these wars, that's driving what we're seeing in Palestine, that is driving what we're seeing in DRC, that the green economy is premised on the exploitation of the DRC. That, what we're seeing in Sudan, and I think, and the deep inequality that we see here. And that part of the reshaping of the multilateral order isn't just around, or the world order isn't just about these institutions. It's also a fundamental reckoning with the economic system that underlies all of our societies, and that it's not sustainable, but what gets created afterwards.
So I won't say it's a hopeful note, but that's a good note to end before we go into lunch. So there is lunch outside. Before we let our panelists go, please join me in thanking them for what was an exhilarating panel.
Enkosi.
Sanbonani, Dumelang, Goeiemorgen, good morning, Salam alaikum. We are really happy to come back after lunch. Hopefully we are awake and hydrated. We have an excellent panel waiting for us this afternoon, and for those listening at home, please enjoy the comforts of air conditioning or fans, even handmade fans, because we are enjoying the lovely Durban heat. So this afternoon we are going to speak with our panelists who focus on the international legal response. And it's no surprise that we have members here of the panel that speak from experience, having been at the ICJ to put forward South Africa's case on the Genocide Convention. Just order of proceeding at this point to remind you that most lawyers love to say this phrase, the matter is sub judice, which means we may not ask Advocate du Plessis any specific questions about the ICJ decision. As you well know, that decision is not over. We still have the merit stage that will happen, so he'll be speaking around the topic for today. It is my honor, I am Professor Veline Holness here from the University of KwaZulu-Natal, to give a very quick introduction of who our speakers are. And this format this afternoon is quite formal. We'll call them up to do their presentations, and then we will have a more informal question and answer session thereafter. So please write down your questions for that session. First, we will have Professor Zozo Jani-Mango, and she is a professor and head of Department of Public Law at the University of Pretoria at the Faculty of Law. Prior to joining academia, her experience was a law clerk at the Constitutional Court for Justice Sandile Ngobo, and that we have in common, not the judge, but the court. She also was an intern in the Chambers section of the United Nations International Criminal Tribunal for Rwanda in Arusha, Tanzania. Following her, we will have Advocate Max du Plessis, SC. He's an international lawyer with chambers in Durban and London, who has been involved in cases before the International Criminal Court, the African Commission on Human and People's Rights, the US Supreme Court, and the Israeli Supreme Court. Then we have our very own Dr. Christopher Gievers, homegrown. He teaches international law and legal theory in the School of Law at our university. He has written extensively on topics of international criminal law, third world approaches to international law, and critical race theory. He has also advised and assisted litigants in cases involving international law in South Africa and abroad, and he spoke with authority about the Costas 4 case. So we are pleased that we will hear more about that, perhaps at another forum. And then we have Dr. Sheetal Soni. Dr. Sheetal is a senior lecturer at our institution. Her areas of research are in international law, bioethics, and intellectual property law. She's also an attorney of the High Court of South Africa. So without further ado, I'll call on Professor Jani-Mango to present.
Good afternoon. I know that you just had your lunch, so it's fine with me. I prefer you sleeping anyway. Thank you for that lovely introduction. It reminds me of the time when I was young. So firstly, I would like to thank the organizers, especially Chris, for this invitation. It's good to see friends and colleagues I haven't seen for some time. Also wary of the fact that I'm following in the footsteps of the speakers in the previous session,
And I'm also put amongst the heavyweights. I don't know who was thinking what when they included me in this panel. But I will try my best. My remarks are on the topic of today on international law, South Africa, and the question of Palestine, focus on the violation of international humanitarian law. But I promise I'm not going to give you a lecture on what international humanitarian law is. But I decided to specifically focus on those violations because there has been reports on how international humanitarian law has been violated during this current conflict between Israel and Hamas. We have seen on TV, media, reports, and the ICJ has also stated as factual some of the attacks that are happening there and what has happened. These include the killing of civilians, including children. We have seen reports about journalists being killed, doctors. There have been reports about the destruction of schools, universities, and cultural property. Images of dead or injured children will forever be stamped in our minds. There is no food, there is no water. Any other inhumane act that you can think of is currently happening there. And of course, the defense by Israel is that they started it. Hamas started it on the 7th of October. But as far as I know, when it comes to international humanitarian law, vengeance is not permitted at all. And the law applies to every party to a conflict. So it's not as if we are saying international humanitarian law will not apply to the other side. Now, I said I will talk about international humanitarian law. Of course, it is applicable in this conflict since the 7th of October, when the attacks by Hamas against Israel happened. Of course, the question has been whether the Geneva Convention, the fourth Geneva Convention, which protects the civilian population, is applicable in this conflict. It does. The ICJ has answered this question in the legal consequences of the construction of wall advisory opinion, that the fourth Geneva Convention of 1949 does apply in the conflict between Israel and Palestine. Israel, of course, is a high contracting party to the Geneva Convention, the fourth Geneva Convention. It has been confirmed to be the occupying power. The ICJ, in that legal consequences advisory opinion, also referred to the Security Council resolutions that have reaffirmed that the fourth Geneva Convention is applicable to all the territories occupied by Israel since 1967. The high contracting parties of this convention have also reaffirmed the application of the fourth Geneva Convention to the occupied Palestinian territory, including East Jerusalem. And lastly, Palestine has declared that the fourth Geneva Convention will be applicable to them since 1982. So that's why I am arguing that it is applicable. That we shouldn't even be asking questions about that because, as I've said, the ICJ has confirmed this as well. So why am I being elaborate, telling you about the application of the Geneva Convention for? It's because I want to show that there has been a breach of several provisions of this convention, which, as I've said earlier, was adopted to protect civilian population, to protect those who do not take part in hostilities. The convention is very clear that under no circumstances the protected persons and their property should be targeted during the hostilities. So that is the law. I'm not going to go to all the provisions of the Geneva Convention, but I will mention just a few as I'm talking. But this takes me to one fundamental principle of international humanitarian law. Because if we are going to refer to the Geneva Convention's applicability to this, we must talk about the principles of international humanitarian law. I'm not going to talk about the principle of distinction, which has been breached. I'm not going to talk about proportionality, which hasn't been breached. But I want to talk about the principle that we tend to forget about when we're talking about international humanitarian law, its applicability, and that is the principle of humanity that encompasses all of these principles. It's about the humanity of all those who are involved in the conflict, especially the protected person. It's based on the Martens Clause, which basically says that in circumstances where a case is not covered in the international humanitarian law treaties, the conduct of the parties to a conflict will be regulated by the principle of the law of nations, the laws of humanity, and from the dictates of conscience. This principle is reflected in Article 27 of the Geneva Convention 4, which states that the protected persons must be treated humanely. They must be treated humanely. What does this mean? Well, when I looked at the 1958 commentary of this provision, it does not really say what being treated humanely means. And then I look at Article 147 of the same convention, which deals with the grave breaches of the Geneva Convention, and it talks about the inhuman treatment as a grave breach. Now, the commentary to this provision, Article 147, refers to the treatment in Article 27 that they must be treated humanely. And it says that the treatment, the inhuman treatment refers to the treatment which ceased to be human. So we might not know, we know what being human means, even though the the Geneva Convention does not explain to us what it means. But the explanation of the commentary that talks about inhuman treatment says it means a treatment which ceased to be humane. And that is a grave breach of the Geneva Convention. Now, I looked at the dictionary meaning of what is meant by this humane. The dictionary online that I quickly checked, I think it's a credible one. It said it is an adjective characterized by tenderness, compassion, and sympathy for people and animals, especially for the suffering or distressed. And secondly, it says it's acting in a manner that causes the least harm to people or animals. That's what humane means. So treating protected persons humanely also means that even in instances of an armed conflict, the parties to a conflict must ensure that the human dignity of the protected or vulnerable persons is kept intact. I heard DJ Zane Dango earlier saying that South Africa's reason for taking on this case was to seek the protection of the Palestinian people from being killed. And to my mind, that means that South Africa was thinking about the humanity of the Palestinian persons, as is found in the principle of humanity and also reflected in the Fourth Geneva Convention. So what concerns me more is this destruction of cultural property, the destruction of schools and universities, because to me this means that this is an intention to remove the Palestinian people's identity, their humanity. Because one's identity is closely linked to one's humanity or human dignity. So the law is clear, I've just mentioned, just few provisions on this. So I do not know what is happening. But I'm very appreciative of states such as South Africa in this case, Namibia that is involved in the occupation of Palestine, advisory opinion, and these are states with a history of the majority of people being treated inhumanely, despite the existence of this principle of humanity under IHL. And appreciative of these two countries because they took these issues up to the ICJ, because we see that some of the civilized Western nations are not interested in ensuring that all persons, irrespective of where they come from, should be treated humanely. This also reminds me of what happened to black people during the beginning of the Russia-Ukraine conflict, where when they were being evacuated, they were last in the queue, or they were taken to be last. And that also means that that principle of humanity was forgotten about. In conclusion, the law, IHL, is about the protection of persons, especially the vulnerable persons, those who do not take part in the hostilities. And it's very clear with this law, IHL, especially the Geneva Convention 4, it's very clear about the obligations of the contracting states, such as Israel, what they can do and what they cannot do when it comes to the protected persons. So why is Israel still committing these atrocities even after the provisional measures were handed down by the ICJ? What about individual criminal responsibility of those who are committing these atrocities? Why is the ICC prosecutor not doing anything? I'm hoping that my colleagues were going to answer that question. Thank you.
Thank you very much. I'm going to start with a disclaimer, if I might, and that is to say that I'm speaking here not as an advocate. It's nice that I was introduced that way, but I'm in fact speaking to you as an honorary research fellow at the University of KwaZulu-Natal. I'm very proud to be able to come back, in a way, to this institution where for many years I taught as a professor of law, including, it turns out, Chris Givers. And so it's wonderful to be able, and Sheetal, and Valine. I was also here for longer than I realized. And so it's wonderful to be able to come and speak to you and to be in a place, in a building where for many years I'd lectured. I also, obviously, am very delicately going to be talking about a case which has already been decided, but which is ongoing. So you'll forgive me, I won't be able to take any questions about it, and I deliberately, as you'll see, am not speaking about the case and what happened in the case and the merits of the case, but I want to speak about and around the case, because I think it teaches us a number of very important things. And I'm going to talk to you about three things, which I think are important as international lawyers, and which transcend the case. The first topic I'm going to speak on is what I've called context as contest, and I'll explain that in a moment. The second topic I want to speak on is the importance of framing cases as objectively legally determinable disputes. And the third topic I'm going to speak on is the topic of jus cogens, the idea that certain norms are so peremptory, are so profound, are so absolute that they transcend the politics of a dispute, and they therefore call for particular consequences in response to that dispute. So those are my three topics. Let me start with the first one, the tongue twister, context as contest. You will have seen that the case that was decided before the court, and I say nothing controversial here, set up two different contexts that were in competition with each other. The first for Israel was to focus on the despicable events of October 7th and to frame the case about the rights of self-defense. By contrast, or in contest, South Africa historicized the case. It contextualized the case's features, and it stressed that Israel's conduct must be seen as that of an oppressor that for years had acted with impunity and disproportionately. And so South Africa had deliberately sought to frame the case within a particular context. It used these words in the application orally as it was presented to the court on the 11th of January. It said, to situate the right to exist and the threats to that right requires the court to appreciate that this application by South Africa is brought within a particular context. What is happening in Gaza now is not correctly framed as a simple conflict between two parties. It entails instead destructive acts perpetrated by an occupying power, Israel, that has subjected the Palestinian people to an oppressive and prolonged violation of their rights to self-determination for 56 years. And those violations occur in a world where Israel for years has regarded itself as beyond and above the law. And we quoted for that statement the UN Special Rapporteur on the occupied Palestinian territories, who said in 2022 the following: the occupation by Israel has been conducted in profound defiance of international law and hundreds of United Nations resolutions with scant pushback from the international community. So that was the framing that South Africa brought to the case. And I want to speak beyond the case because it seems to me there remains very important work to be done in reminding about the broader context of disputes in any international forum. Now, where does that take us? Well, it takes us straight to next month, to February. It takes us to next February because, as Christopher pointed out in his opening remarks, there are hearings that are taking place before the International Court of Justice around an advisory opinion that has been asked of the court. And that flows from a United Nations General Assembly request to the court. And the court has decided to hold public hearings in response to that request for an advisory opinion, and it has done so in respect of what the case is now called. Again, in respect of Palestine and its issues, there's always a long case or a long title. It's called the advisory opinion in respect of the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. Those hearings will open on the 19th of February at the Peace Palace in The Hague. So part of that debate, part of what will take place there, is a contextual question, a framing of what the occupation has become, whether the occupation in and of itself can remain something which we call lawful, or has it transcended particular norms so that it has become unlawful under international law. And just last week, Victor Katan and Gerard Kemp wrote very powerfully in Egil Talk, one of the blogs that international lawyers like to follow. And they said something that is particularly interesting. They said, and I'm quoting them, South Africa's application instituting proceedings against Israel under the 1948 Genocide Convention would not have been possible under the International Convention on the Suppression and the Punishment of the Crime of Apartheid. So just to understand what they're saying. The case that was brought before the ICJ for provisional measures under the Genocide Convention, they tell us, could not have been brought under the Apartheid Convention. Why? Because, they continue, neither South Africa nor Israel are parties to the Apartheid Convention. And even then, owing to the peculiar wording of the dispute resolution clause, both parties would have to agree to refer their dispute to the court, and that wouldn't have happened. Even so, they say, South Africa's application for provisional measures contains numerous references to Israel's apartheid policies that could be read as a kind of phantom application pertaining to apartheid because of the structural similarities between the definition of genocide in the Genocide Convention and the definition of the crime of apartheid in the Apartheid Convention. This is important to simply again highlight the outside importance of the context. The arguments, the framing, the context are now increasingly becoming important. International scholars are drawing attention to that outside importance of the context in framing not only what the legal disputes are, but how they should be answered. And those debates by scholars like Katan and Kemp include crucially the importance of self-determination. So the very question of Israel's occupation is now being considered by the ICJ in the advisory opinion hearings next month. And many states have filed submissions. I think Chris highlighted that there were more than 50-odd submissions. They include submissions around Israel's occupation and the violation thereof of the jus cogens norm prohibiting any occupation which flouts the right to self-determination and which constitutes apartheid. And submissions there will then debate this broader context, and the ICJ's advisory opinion will help to situate the answers to these questions within that broader context. And where in that context you're going to see a contestation about whether what Israel is doing is a particular form of occupation which is lawful, or whether it has transcended certain norms, including the prohibition on apartheid, thereby found itself to be an unlawful occupation. That is therefore my first point to highlight. Context as contest, and international law in relation to Palestine increasingly being about a contested context and the importance of framing in that way. That leads me to my second point. It's that the law, objectively determinable, is a critical means by which these types of political disputes can be resolved. There's been much said about the ICJ case. There's been criticism of the politics involved. I've got nothing to say about it. I'm not a politician. I leave the politics to others. And I won't, as I say, speak about the case itself, for obvious reasons, as the counsel in the case. But I can note four externalities, four external legal facts, which I think are interesting in and of themselves. The first is this. I can say, noticeably, that the legal team that was assembled to represent South Africa was objectively chosen. It included numbers of counsel that are often advocates against the government. Just as one example, it was pointed out by Karen Moore, a journalist, that it included myself, who had acted for the DA in a case around whether President Putin's arrest warrant by the International Criminal Court should be endorsed by South Africa's government before the BRICS conference. And in that same case, my opponent in the matter was my friend and colleague, Tembeka Nkaitobi. He acted for the government. We were on opposite sides of the case because that's what advocates do. They are briefed to represent the best of the arguments and for a judge to decide. And in the best tradition of the bar, I would like to say that that's exactly what happened here. The case was run by independent counsel that put the legal case as strongly as possible before independent judges. And the law was argued through the ICJ's own precedents, through a very careful marshalling of the facts, through reliance on United Nations experts' reports and special rapporteurs as sources, and a legal judgment ensued. Law, above all else, despite that acute political environment, I think was what ultimately ensued. It was expressed as well, notably by the UN's highest legal body. So that's the first point. Objective determination through objective lawyers in a case arguing the facts as applied to the law objectively. The second point is this. South Africa's case was to highlight equality. It highlighted that the rights of the Palestinians include the right to exist. But here's the important point that a South African could be very proudly drawing attention to, and that is that the rights of the Palestinians to exist are equally worthy of protection, as are all the other parties who had previously come to the ICJ and had received provisional measures in their favors. The rights of the Palestinians for years have not been seen as worthy of equal protection. They've been flouted. And it was an important moment to highlight for the court that their rights are equally worthy of protection, certainly not less worthy of protection. And the third point is this. It was noted by commentators, for example, Kenneth Roth, who pointed out in The Guardian just after the judgment or the decision of the court had been handed down. And he said this. He said the ICJ judgment is a repudiation of those who had criticized South Africa's case because, and I'm quoting him, he said, the Biden administration had called the suit meritless. The British government had said it was nonsense. But by a vote of 15-2, the ICJ judges found otherwise. That is a legal repudiation of statements that had been made by governments that were politically critical of the South African case. Again, a legal response. And the fourth point is this. Israel confirmed by its conduct that the law counts and must be taken seriously. I say that because Israel sent a serious collection of lawyers to defend its case to The Hague. And it appointed its most famous Chief Justice as an ad hoc judge. And that is good. That's good for the international rule of law. It means that you can have serious disputes, seriously litigated, and ultimately seriously adjudicated. It highlights the power of the law to speak objectively and powerfully into disputes and to help their resolution. And that leads me to my third and final topic overall. It's the topic of jus cogens. In the discussion on rights, the South African team had said the following in their address to the ICJ. They said, moreover, South Africa stresses that any motive or effort by Israel to destroy Hamas does not preclude genocidal intent towards the whole or part of the Palestinian people in Gaza. Evidence of other motives explaining its conduct as a perpetrator will not save Israel from a finding that it also possessed the requisite genocidal intent. Why? Because the South African team said this. They said, because a fundamental feature of genocide, the prohibitions on genocide and associated offences, are jus cogens in nature. They are therefore subject to no exception or qualification. They are absolute in nature in times of war and peace, always and everywhere. That was what had been argued. Again, I'd like to lift out three related consequences outside of that to stress the resonance of jus cogens norms for us. The first is this. The obligations, when you're talking about a jus cogens norm, resonate higher and further than other obligations. I'll give you one example. Article 41, paragraph 2 of the Articles on State Responsibility, which are effectively the Bible on state responsibility for international lawyers, and which reflects customary international law, says as follows. It says, no state shall render aid or assistance in maintaining the situation created by a serious breach of a peremptory norm of general international law. And South Africa knows that well, because in the Namibia advisory opinion, in which South Africa had to defend its conduct in Namibia as apartheid policies and practices, the ICJ held as follows. It found against South Africa, and it said that states members of the United Nations are under an obligation to refrain from any acts, and in particular any dealings with the government of South Africa, lending support or assistance to the presence and administration of South Africa in Namibia. And the court issued that dispositif after finding that states had a duty to, and I'm quoting, abstain from entering into economic and other forms of relationship or dealings with South Africa on behalf of or concerning Namibia, which may entrench its authority over the territory. Those words are obviously of continuing relevance today, and they are now playing themselves out before the United States courts. The Center for Constitutional Rights has brought a case against the Biden administration for aiding and abetting the crime of genocide. And arguing before that court in Oakland, California on Friday last week, the senior attorney, Catherine Gallagher, pointed out that the United States government had confirmed in a submission to the ICJ in the Ukraine's Genocide Convention case against Russia, that the obligations contained in the convention, which include an obligation to prevent genocide, are, quote, binding on all states. She continued, and this is quoted in a report by Karen Morn, who was listening to the arguments, she continued as follows. She said, that obligation to prevent, suppress, and punish genocide also applies to the State of Israel. And we had a judgment this morning out of the International Court of Justice that made that quite clear, she said. So you're seeing how the ICJ's decision is resonating beyond it to highlight the importance of these types of norms and the obligations that they place upon states far away from The Hague, but in relation to what is happening in Gaza itself. There's a second resonation, a second importance of a jus cogens norm, and that is before the International Criminal Court. The International Court of Justice does not deal with individual responsibility. Only the ICC does, or states that are parties to the Rome Statute and use universal jurisdiction. And so what you know is that the International Law Commission has explained that where there's a violation of a peremptory norm, for instance, genocide, that triggers a related obligation on states to take whatever measures they can to hold those perpetrators accountable. And the obvious place for that to happen is the International Criminal Court. Indeed, the special rapporteur, the previous special rapporteur on the occupied Palestinian territories, Ms. Albanese, in her latest report, specifically recommended that the international community pursue accountability for perpetrators through both the ICC and its ongoing investigation into the situation in Palestine and universal jurisdiction mechanisms. And, sorry, she's the current special rapporteur. Her predecessor, Mr. Link, similarly recommended in his final report that the international community support any references or applications to the ICC. And so the ICC, as you know, has been asked by Palestine. It's also now been asked by a referral on behalf of South Africa to investigate these offences and to ensure if there is evidence, credible evidence of crimes having been committed, that individual criminal responsibility follows. And then third and finally, and I close with this, the importance of the jus cogens norms also means that there is an ability for this to do its work diplomatically. South Africa's application to the ICC for interim measures was described by a peace negotiator, Israel's former peace negotiator, Mr. Daniel Levy, as follows in a 17 January 2024 essay in the New York Times. And I'm quoting him. He said, South Africa may have already done more to change the course of events in that conflict than 3 months of American hand-wringing. If that was all that the South African application achieved, it achieved a lot. Thank you very much.
Thanks, Max. So weirdly, I'm going to arrive at the same conclusions as Max, which leaves me a bit unnerved. But I will take much longer to get there. So at least I will be an academic more than a practitioner. So I want to say a few things about the International Court of Justice in South Africa. So these are heating up. And I've titled my talk, if I can read it, Tell No Lies, Claim No Easy Victories, South Africa at the ICJ Again. And those of you might recognize the aphorism, which is from Amilcar Cabral, which is tell no lies, expose lies whenever they are told, mask no difficulties, mistakes, and failures, and claim no easy victories. And I want to make 4 points based on each of those incantations. So before I do that, let me tell a story, because this is a story that we don't tell often enough and should be more widely known, which is that this is not the first time South Africa has been at the International Court of Justice. In fact, in 1960, at the Second Conference of Independent African States, there was a vote taken to take South Africa, apartheid South Africa, to the International Court of Justice in the name of Liberia and Ethiopia, but funded by all African states in order to challenge the implementation of apartheid in what was then mandated Southwest Africa. And the idea was understood that if we can challenge apartheid in Southwest Africa, where we have jurisdiction, it would resonate in a challenge to apartheid in South Africa. And the case had a good had good chances of success because it was based on a number of other decisions from the ICJ that were favorable to the case being made by African states in the name of Liberia and Ethiopia. And in fact, the case got off to a good start. So in 1962, there was a preliminary decision by the International Court of Justice confirming that Liberia and Ethiopia, as members of the League of Nations at the time when South Africa was granted the mandate, had jurisdiction to bring the case, or had an interest in the case such that their case could be heard. So what happened in 1966 is well known to, at least to international lawyers, and what African states at the time called a scandalous and wicked judgment. The International Court of Justice reversed its decision. Not just its decision on the merits, but actually went back and reversed its 1962 decision. Now, it was able to do so not because of a legal argument, but because of the shenanigans of the, I'm sorry to say, the Australian judge, Christopher, and the British judge, who essentially lied to the Pakistani judge so he would recuse himself to change the balance of judges on the court, and then by a vote of 7-7 with the Australian judge having this deciding vote, they simply reversed their own decision. And we only know this now because of the work of people like Victor Catan and others who have shown that it was just basically judicial subterfuge that led to the decision being reversed. And this in fact led to the court falling out not just with African states, but with the court, with states more generally. So in fact, the court went into a bit of hibernation after '66 for a number of years because of this scandalous decision. But there's another story that emerges, and that's what happens in the aftermath of that decision in South Africa. And I think we need to start our account there today. So the advocate who brought that case on behalf of South Africa was a guy called Verloren van Thermaat. He passed away during the proceedings, but when the decision came out, the white settlers in Southwest Africa were so excited about the decision that they donated a whole lot of money to UNISA to set up the Verloren van Thermaat Fund for International Law in the 1960s. So Hercules Boersen, who was a professor of international law who took over the fund later, reasoned that the rationalization of the settlers for this decision was as follows. Perhaps they thought in an upsurge of unjustified faith in the objectivity of law as a result of the 1966 decision that the ICJ, that public international law, would be capable of protecting them against the inevitable black Africanization tide rolling relentlessly southwards. Right? So that fund established by white settlers in Southwest Africa, which established the Verloren van Thermaat Fund for International Law, would then, along with money from the apartheid state and with money from the companies that were busting sanctions at the time, would fund the establishment of the first two international law journals in South Africa. So the Comparative and International Journal in South Africa was established in 1968, funded for a decade at least by money from the victorious white settlers in Southwest Africa case in 1966. The South African Yearbook of International Law also was established in the 1970s using the same fund. And then perhaps most scandalously of all, the Verloren van Thermaat Center for Public International at UNISA was established with this fund and ran, I think, still under that name to this day. Perhaps they've dropped the Verloren van Thermaat. And I tell that story for a number of reasons, but it's important to point out that money ran out miraculously in 1994. All of a sudden, there was no more money for international law, and that story is only told, we've never heard that story from the journals themselves, it's told by Hercules Boersen in his little red biography. He now lives in Australia. But it's important because not only because of what it says about South Africa and international law, but because when we watch our TV screens, the ghosts and zombies of that Verloren van Thermaat Fund occasionally have been on the screens in the last couple of weeks and months, some of them who are still associated with that very center at UNISA. So let me say 4 lessons from 1966 and its aftermath and the key of Amilcar Cabral. So first, tell no lies about international law. So the 1966 decision reminds us that international law was the engine and freight of colonialism and remains colonial in many respects in the present. In fact, Israel's invocation in recent times of the language of barbarism and civilization is not mere rhetoric, it is an attempt to recolonize international law, to invoke its underlying racial grammar in order to demonize Palestinians and their allies as unworthy of international law's recognition and protection, even when they go to the World Court. It is an effort to speak directly to what Chinua Achebe identified as, quote, the West's deep anxiety about the precariousness of its own civilization and the need for constant reassurance by comparison to its others, end quote. It is not a throwback to a language of another time. It is an effort to reset and reassert international's colonial and racial grammar in the present. And I am sad to say it's working in many places. So second, expose lies whenever they are told. So one risk of uncritically placing international law on the side of post-apartheid South Africa is the flattening of international law's own difficult relationship with apartheid, shoring up the common and, quote, comforting myth, again Achebe's words, that international law opposed apartheid. This is at best a half-truth. International human rights law opposed apartheid. The majority of the General Assembly opposed apartheid, but international law and institutions as a whole simply did not. Like colonialism, international law laid the foundations for the establishment of apartheid in 1948, and apartheid lasted as long as it did because of, not in spite of, international law and its institutions, including the Security Council, as we know, and for a time, the International Court of Justice. Moreover, international law, including international human rights law, was instrumental, to paraphrase Professor Ramosa, to the reduction of the question of freedom post-1994 to the constitutional recognition of the civil rights of the conquered people of South Africa through merely their inclusion in an all-inclusive constitution, rather than the restoration of the full, integral, and comprehensive and an unencumbered sovereignty to the indigenous peoples conquered in the unjust wars of colonization, end quote. In this respect, the 1966 decision reminds us, importantly, that South Africans did not get good at international law overnight, or even in 1994. The uncomfortable truth is that apartheid South Africa was very well versed in the language of international law. Third, mask no difficulties, mistakes, or failures. So in 1966, there were difficulties, mistakes, and failures, and we should acknowledge them and learn from these. These are often drowned out by the scandal of how the court came to the rule against African states in 1966, namely by the collusion and fraud amongst the British and Australian judges to engineer a majority and reverse its own earlier decision. We don't know what would have happened if that decision had been made on the merits in 1996, but the assumption is generally made that Liberia and Ethiopia would have won, and the ICJ would have ruled that apartheid violated international law. Truth be told, if one reads the case closely, that outcome was far from certain. The first mistake in 1966 was the decision by Liberia and Ethiopia to hire a long-time servant of the State Department as their lead counsel, a mistake that has been easily corrected in this particular case. The other cracks that emerged in the case against apartheid in the 1960s are more difficult to avoid. They have to do, firstly and foremost, with two legal tactics apartheid South Africa employed, which have already been mirrored by Israel in the ICJ proceedings. The first was to take technical points endlessly, such as whether or not there was a dispute or a unispute. The second was to produce alternative sets of facts about the conditions of Southwest Africa that contested the UN's narrative at the time, and more importantly, the accounts of those directly affected, then Southwest Africa and today the Palestinians. So South Africa has done well to counter both these tactics, and the court last week came down on the side of the UN and South Africa's well-documented account of the situation in Gaza. However, the most fateful mistake of African states in 1966 was to place all their faith in the justice of international law and its ability to jump its own colonial shadow. In short, the lawyers for Liberia and Ethiopia ended up relying solely on the claim that apartheid by its very nature violated international law. And it's not certain by any means that they would have been successful, but even if they had, it would have been on the hardest available legal point. In the current proceedings, South Africa, for reasons of jurisdiction, has no choice but to make the hardest possible argument, that Israel is not only wantonly destroying the lives, homes, and livelihoods of Palestinians, but that it is doing so with the intention to destroy them as a group. There is no other route to the ICJ other than through the eye of this particular needle. It would be far easier, for example, to prove that Israel is committing various other human rights violations or war crimes and crimes against humanity. But to seize the court, it must rely on the Genocide Convention's compulsory jurisdiction clause. Here too, ironically, the spectre of 1966 looms large, as it was because of the ICJ's betrayal of African states in 1966 that there is no compulsory jurisdiction clause in the International Covenant on Civil and Political Rights, which was being drafted at the time the judgment was handed down. Had one been included, South Africa's case before the ICJ would have been far simpler today. However, and this is where I'm eventually getting to agree with Max, there are other more hopeful and radical arcs from 1966 to the present, and I want to focus on two in particular. The first is the basis for South Africa's claim, namely that Israel's genocide against Palestinians in Gaza does not only affect their rights alone, Palestinians' rights alone, but implicates the rights and obligations of South Africa and other states, as the prohibition on genocide is a jus cogens norm that generates obligations erga omnes partes, to use the Latin terms. So simply put, this means Israel's obligation not to commit genocide is one it owes to all other states, in view of their common values and concern for compliance, so that the breach of that obligation enables all these states to take action against Israel. This was the justification underpinning African states' case in 1966, and it was rejected, namely that apartheid South Africa's obligations in respect of Southwest Africa could be enforced by other states and by African states in particular. This radical approach to international justice is the true heritage of 1966. The second arc from 1966 to the present passes through 1973. In the wake of the ICJ's scandalous and wicked judgment, African states turned to the General Assembly, but did not abandon international law altogether. Rather, they sought to reimagine and remake international law in order to ensure it would be on the right side of history and on the wrong side of apartheid. The centerpiece of their efforts was the Apartheid Convention, which not only declared apartheid a crime against humanity and provided for both universal jurisdiction and a jurisdiction clause for the ICJ to adjudicate violations thereof, but drew a link expressly between colonialism, apartheid, and genocide. By doing so, it rejected the claims that either genocide was unique to the Holocaust or that apartheid was unique to South Africa. And by doing so, the Apartheid Convention adopted a structural account of the crime of apartheid as a system of political, economic, social, and cultural domination, as opposed to a series of individual rights violations, and by implication extended this account to the Genocide Convention, as mentioned by Max the piece and by Victor and Gerard sets this out. So it was precisely this historical and theoretical understanding of the situation in Gaza that South Africa's lead agent, a graduate of this school I might add, invoked at the outset of the proceedings in The Hague 2 weeks ago. Namely that, and I quote, "The ongoing Nakba of the Palestinian people through Israel's colonization since 1948, which has systematically and forcibly dispossessed, displaced, and fragmented the Palestinian people, deliberately denying them their internationally recognized inalienable right to self-determination, and imposed an institutionalized regime of discriminatory laws, policies, and practices designed to maintain and establish domination by subjecting Palestinian people to apartheid." As such, the League agent argued that genocidal acts and omissions by Israel, quote, "inevitably form part of a continuum of illegal acts perpetrated against the Palestinian people since 1948. So notably in 1966, the delegate of Guinea, with hindsight, declared that this was the real mistake of bringing the case against apartheid South Africa before the ICJ for violating the people's rights of Southwest Africa. Namely that, quote, "it distorted the true nature of the problem of Southwest Africa's future, which was a colonial problem." In this respect, the words that concern me most about last week's historical provisional measures order are not only those that were missing at the end, i.e. ceasefire, but those that were present at the beginning. Namely, and I quote, "the court begins by recalling the immediate context in which the present case came before it, 7th of October, 2023. So the success or failure of South Africa's cases going forward will, in my opinion, hinge on its ability to direct and to hold the court's attention to the broader context of colonialism and apartheid that are the conditions of possibility of the ongoing genocide in Gaza. Here, there are no easy victories. International law and human rights have historically, and I would argue still, been hostile to recognizing and redressing structural harms like colonialism and apartheid, or even acknowledging the struggle of the majority of the world's people against them and the traditions and epistemologies they have generated. However, the consequences of doing so will be profound, not only for the immediate case and the question of Palestinian freedom, but for the question of freedom everywhere, including in South Africa. In this sense, taken together, the 1966 moment and the actions of South Africa over the last month remind us of the possibility, but also the fragility of not only another, a different, a more just international order, but of another international law.
Greetings again, everybody. It is a good place to speak after the other speakers in my panel have gone ahead. It gives me an opportunity to reflect more on what I am going to be discussing this afternoon. So my perspective and contribution to the discussion will speak broadly to the principles of international law itself and specifically more international humanitarian law. So there may be some things that I repeat that you've heard before, but I'll reframe them a little bit. I'll talk about numbers and I'll talk about names because I know you watch the numbers too. I know you've heard the names before. And I think it's important to remember that there are humans that international humanitarian law aims to protect. The law itself is abstract and has no meaning outside ourselves. Prof. Zozo, when she spoke about humanitarian law, she says that, what does it mean to be human? International law doesn't really tell us that. It talks about crimes against humanity, tells us not to dehumanize people or subject them to inhuman, degrading treatment, but that definition of human is something that we can't contextualize outside ourselves. We'll understand inhumanity when we see it. We'll understand inhumane treatment when we see it. One example is our understanding of crimes against humanity under international law, which are broadly described as acts that are so shocking that they shake the very conscience of mankind. So international humanitarian law, we can describe it as the mother of human rights in conflict situations. And while we look at it a lot of the time from the perspective of civilians who are not involved in a conflict, it also exists to protect the rights of combatants. There's laws of war. But it's the civilians that will bear the gravest consequences of these conflicts. And much of the international humanitarian law concentrated in the 4 Geneva Conventions and the protocols that nations worldwide have adopted. So to take us back to October 7th, and the reason why I'll mention this for a minute is just so that we can sort of contextualize what came after. If the court wants to focus from that point, we'll consider that context. So on October 7th, Israel was attacked by the Hamas militant group, who not only committed an atrocious series of attacks that day, but also took hundreds of Israeli citizens hostage. Israel responded by unleashing an attack of unprecedented proportions. To date, to this day, the bombs that have been dropped in response to these attacks exceed 65,000 tons. In the first 3 weeks of the conflict alone, the amount of force that was inflicted in the bombardments on Gaza exceeded the bomb that was dropped on Hiroshima in World War II by more than 1.5 times. The military campaign was justified and is being justified by Israel as self-defense, which is a right under international law in the Charter of the United Nations, and several nations, the United States, the United Kingdom, etc., support this right of self-defense of Israel. The International Court of Justice has affirmed that there are requirements in order to invoke this right. And the one that I want us to consider is that requirement of proportionality. And that's where I'd like us to think about some numbers. So to date, in more than 113 days of conflict, which does take place in the context of 27,650 days of occupation, more than 35,000 civilians have been killed. And this number includes people that are missing and presumed dead under the rubble. More than 12,700 children have been killed. And in the first 3 weeks of the war, the number of children killed at that time exceeded the total number of children that had been killed in conflicts across the world over a 3-year period. And that was 3 weeks in Gaza. This statistic alone led the Secretary General of the United Nations, Antonio Guterres, to describe Gaza as a graveyard for children. More than 117 journalists have been killed, more than 223 healthcare facilities targeted, destroyed partially and completely, more than 337 healthcare workers killed, more than 100 of healthcare workers detained, more than 64,000 civilians injured, more than 2 million people displaced, more than 263,000 homes destroyed, more than 378 facilities of learning, including schools and universities, destroyed, and more than 2,600 civilians forcibly detained. So when we look at those numbers, the destruction and the loss of life does not lend itself to an indication of proportionality by any means. The legitimacy of self-defense in an occupied territory having been considered by the ICJ before. What we can actually consider the Israeli military campaign as is the collective punishment of a civilian population. And despite the assurances given otherwise, we've not yet seen an effort to respect principles of humanitarian law. In the past few months, we've seen deliberate targeting of civilians and indiscriminate bombing of civilian infrastructure like hospitals. International humanitarian law exists to protect civilian populations, combatants, as I said, and detainees, even in the occupied territories, where, as my colleagues have mentioned before, the State of Israel has a right unto itself to protect the population in the territory that it's occupying. Women and children, wounded and sick persons, relief humanitarian and medical workers, their installations and means of transportation must also be protected under humanitarian law. They must be able to work despite the hostilities. Pregnant women, newborn infants, and infirm persons especially enjoy particular protections as they are especially vulnerable during these times. But what is the reality on the ground? The reality is that basic services have been suspended. Fuel, water, electricity, medical personnel, schools and hospitals, clinics, all targeted, all on the basis of paralyzing the Hamas operatives. During the 4-day humanitarian pause in late November, called for the purposes of a hostage exchange, Israel arrested and detained more Palestinian civilians than it had released during that 4-day period. All of these acts together are identified as war crimes in themselves, and together they do amount to collective punishment, which is prohibited in international law, as an aggressor state singularly unleashes its wrath upon an innocent civilian population as a means of punishing its actual opponent. Hospitals and schools, which international law protects as sanctuaries of healing and learning, have turned into hallways of horror, directly targeted on the suspicion that they conceal underground tunnels and may be used as basis for Hamas operations. These actions corroborate a finding of genocidal intent, which has been documented through numerous audio, video, and written statements made by Israeli soldiers as well as officials of the Israeli government at numerous levels. No concrete evidence of civilian infrastructure having harbored Hamas militants has actually been provided, and the court order issued last week Friday by the International Court of Justice has specifically directed that Israel take steps to preserve evidence relating to possible violations of international law. Not only has there been a flagrant disregard for the principles of international law, but also an unwillingness to act in the interest of humanity. And I'll give you one example, just one of them. When fuel was cut in Gaza, it was done so with complete knowledge that fuel was necessary to run the hospitals, many of them that house critically ill patients. When the supply was stopped, it was done so with this knowledge that critically ill patients would be affected, and these included 39 premature babies in the neonatal ICU ward at the Al-Shifa hospital. The news that the hospital would run out of fuel it gathered international coverage, but that fuel was still stopped. These infants had to be removed from their incubators and kept together on a hospital bed, covered in foils and blankets to try and keep them alive. It took the World Health Organization and Palestinian Red Crescent Society days to enter the hospital safely and evacuate some of those infants with some doctors and some family members. These actions directly violate not only, international law, but basic principles of law that we find in the law of all nations: the right to health, the right to life, the right to receive emergency medical treatment. History will remember a lot of things at this time. It'll remember that in 2023, babies were removed from their incubators because the state at war with the militant group cut off supply as a means of neutralizing the enemy. Instead, this act had consequences on the infants, as well as countless other Palestinians whose names, faces, and stories were displayed to the world by journalists in Gaza. We'll remember this time because it's the first conflict in history where the world can witness through technology in real time what's happening on the ground in Gaza. We'll remember children like 12-year-old Dunia Abu Mohsen, who was recovering in Nasser Hospital in Khan Yunis after surviving an Israeli airstrike that killed her parents and siblings, only to be killed when an Israeli tank-fired shell hit the hospital and struck her directly on December 17th. We'll think of pregnant women who were on their way to hospital to deliver their babies, who were gunned down in Gaza's Tel al-Zatar on December 23rd. We'll remember Hal Krias, a grandmother killed by an Israeli sniper when she was walking along an evacuation route with her young grandson, waving a white flag on January 13th. And we'll remember the words of Dr. Mahmoud Ab-Nujalia, which was scrawled on a surgical ward whiteboard at a hospital in Gaza. We did what we could, remember us. And we'll remember the days that the pleas of the Palestinian population were no longer save us, but save the rest of us. We'll remember all of this and the countless other casualties, families destroyed, an exponentially rising death toll, decimation of healthcare infrastructure, and the lack of moral courage that we've seen so far by some states to support a ceasefire, which would provide the Palestinian population some respite to access medical care, to access aid. These aren't the only violations of international humanitarian law we've seen. The hostage exchange revealed for the first time for some people that Israeli military forces detain a large number of Palestinian children who are also explicitly protected under international law, and the conditions they're housed in, the care they're given while in detention are unknown. And I must add that Israel is the only country in the world that prosecutes children in their military courts, many of them detained without ever being brought before a judge. When considered in context, it's an assault on international law itself. And what Gaza has shown for the world is a global system historically flawed, and that now is failing to the point of no return. A system that's encouraged impunity and allowed civilians to be used as pawns in a conflict where the ethical and moral imperative to protect the weakest and most vulnerable among us has fallen silent in the background, and places where these people can be given meaning and substance, like schools and hospitals, are systemically destroyed. In early December, I wrote in an article that what was needed was moral courage to apply the principles of international law without fear, to use the international criminal justice structure, like the International Criminal Court, which has the power to prosecute individuals for having committed international crimes described in its statute, or the International Court of Justice, where the Genocide Convention can be invoked. I recall several days where I asked Chris, why aren't we invoking the Genocide Convention? For states to use the rules of universal jurisdiction to prosecute crimes that are of interest to everyone. I wrote that South Africa, having found its freedom from a system of oppression and apartheid, would be well placed to lead a global effort for justice, to use the principles and institutions of international law as they are intended to be used, to protect the innocent and the structures that are aimed to preserve them. And in late December, South Africa did it. We did it. And one of the provisional measures that were granted by the court was the direction that Israel facilitate more humanitarian aid in Gaza. And one of the changes we've seen in the last 3 days, one day after the court issued this order, several states, we all woke up this weekend to the news that several states would be defunding UNRWA, which is the United Nations agency that is responsible for the distribution of humanitarian aid in Gaza, due to allegations that 12 of its employees may have been involved in the October 7th attacks. UNRWA initiated investigations, but the states still cut their funding, despite pleas that this aid is needed. and that there is starvation and a looming famine that exists in Gaza. There are over 30,000 UNRWA employees, but these states cut funding based on allegations leveled against 12 that were being investigated. In law, we are presumed innocent until we're proven guilty, but not in Gaza, where the defunding of UNRWA has concentrated the collective punishment of the 2 million Palestinians that depend on that aid so much more. Without UNRWA, more families will likely starve, there will be more illness, more disease, more malnutrition, more miscarriages, more death to those who have managed to survive the bombs until now. These states themselves, who through their military and political support of Israel's military campaign, are already complicit in a plausible genocide. The court confirmed that this is a plausible genocide. They may also now find themselves directly in violation of their own obligations under the Genocide Convention. And this was also pointed out by Francesca Albanese, the UN Special Rapporteur for the occupied Palestinian territories, who warned that the decision to stop funding UNRWA overtly defies the order that the court issued on Friday to allow effective assistance to reach Gazans. And this will entail legal responsibilities or the demise of the international system. The war is having a divisive impact on the world community. It awakens our collective memories of the Holocaust and the genocides of past, Rwanda, Srebrenica. We must be united in our humanity to protect life and health and the obligations of international law that were created for the very purpose of protecting us all. And South Africa's application to the ICJ and the case that will come provides a beacon of hope in these dark times. And it's reiterated once more that violence against the innocent can never justify any end. Thank you.
Thank you very much for that. We now come to the part where we have a very few minutes available for questions and answers. Before we break for tea, we're probably going to take one round, and then we're going to ask that people ask questions over tea, over a cup of tea or a glass of water perhaps. All right, so let's see hands, please. All right, we've one question at the back, two questions at the back. First, Matthew, thank you.
Okay. Hi, everyone. Thank you for a very interesting panel discussion. My name is Sese Teolumisa, and I'm a second-year politics student at UCT. So, as the panelists spoke of humanity and what it means to be human, I found myself thinking of who was considered human or subhuman when humanitarian laws were created. These were times where imperialism and colonization were working globally very overtly. And so if we consider that when we think of international law, should we not expect it to produce and or continue colonial hierarchies when it's implemented or not, where white supremacy, capital, and patriarchy prevail? And if so, can we reimagine international law without colonial roots so that it truly centers itself in humanity and liberation for all, in the same way we should reimagine the life without capitalism and neoliberalism? Thank you.
Thank you. We'll take the question at the back. Thanks, Lubna.
Thank you very much. As an esteemed panel of legal experts, I would like to know from you what rights do or does an occupied population have in international law? What rights do they have to resist against their occupation? What rights do they have to be protected when they are resisting against their occupation? And what status does a group like Hamas have under international law when it is actually engaging in what many would consider an act of resistance against occupation? Of course, some may call them a terrorist group, but that's a debate. So I'd really like to have your thoughts on that. Thank you very much.
One last question here at the front. Thank you.
Good afternoon. I am Nombuso Zama of Tomlinson Mnguni James Attorneys. I am a practicing attorney. I have two questions to the panelists. Firstly, if Israel is prosecuted at the ICC, how long do you think it would take for the ICC to actually prosecute Israel? If there is a judgment that is handed down, is it going to be a binding judgment? The second question is, with the current provisional measures that has been implemented, how can everyone ensure that Israel complies with the provisional measures, especially when it comes to humanitarian aid? Thank you.
We have more burning questions, but we're going to pause them and just see how this round goes. Thank you. So, yeah, we've got 3 questions, and who would like to go first? Chris, thank you.
I don't recall putting my hand up, but that's fine. So I know that Sheetal's going to answer the third, so let me take a stab at the first and the second. So I think you're exactly right. So this is the question that bedevil's third world approaches to international law. Is there a way that international law can transcend its colonial origins and its relationships to capitalism and patriarchy and white supremacy? So one way to come at this is not to ask whether can we imagine a different international law, but can we not, right? So how do we imagine, can we afford to not imagine in this moment? That we need to, even when it seems impossible, and now it seems actually more possible than it has in a while, to think of other ways of organizing the world in a radical way. I just think we have to do that in a way that doesn't fall back into the reformist projects of old. So we need a revolutionary international law. And I think what I'm trying to say in my talk, and I think what I would encourage other people to listen for in their reading, is to think of other traditions and ways of organizing the world that don't originate in Europe. Right? So think of other traditions and forms of international law. I think, as Max pointed out, the heart of this case is a jus cogens norm. The heart of this case is an obligation erga omnes. These are principles that emerge from African international law. They do not come from Europe. They come from the practice and from the efforts of African states. The Apartheid Convention is an intellectual project of African international lawyers. It's not a project of the Soviet Union. It was the concretization of a particular way of understanding international law in which you could not separate colonialism from apartheid and from apartheid from slavery. Those types of traditions are there, they're present. We have to, in this moment, look for them, to locate them, and I think to lift them up. And I think in that sense, when I think about third world approaches to international law, I've seen more hope and more positivity about the idea of an international that's different than I have in a long time. I will not commit to its existence, but I think we dare not imagine it at this particular moment. And then just quickly on the second point, so I hear this term terrorism. Terrorism is not an international legal term. I think we need to say that again and again. When they say Hamas is a terrorist organization by some countries, they mean countries in the West. This is we have to make sure that when we're talking about international law, we acknowledge what's a legal argument and what's not a legal argument. And as you point out, there is a right of self-defense and there's a right of self-determination. And the people of Palestine, amongst their many other rights, have a right to self-determination, including the right to take action as long as it doesn't violate international law. Right? And I would argue that includes a right of armed resistance against occupation. The most clear articulation of this was one of the very first statements by President Ramaphosa, which said exactly that, which is radical in international law, because when I say it, when other people say it, we get in trouble. But President Ramaphosa said that Palestinians have a right to self-determination, including armed resistance, within the bounds of international law. If we say that enough times, perhaps the reality will change.
Thank you. I think I have just a few minutes to quickly answer the third question. So thank you very much for that. You asked a series of questions, and I think just broadly a couple of things. The first relating to the International Criminal Court and how quickly we could potentially see Israel being prosecuted for various crimes. The next question was related to how the judgment or a judgment could be enforced. Yeah, so look, I think this goes a good place to start would be the provisional measures order that was granted in favor of South Africa last week Friday. And when we look at that provisional measures order, I think there's been a mixed reaction to it. The glass half full or the glass half empty, basically dancing around the lack of the word ceasefire in that order. But if you really look at the measures that the court ordered last week, one of the things we must remember is that we need to stop this genocide that's occurring in Gaza, and there would be ways to do that. But I think what we must be cognizant of the fact is that Israel isn't fighting this conflict alone. It fights with the military support of the Western nations. And if you look at the order that was issued last week, I think one of the most, obviously the most significant finding of the court was that it is plausible genocide. And so while Israel has been flagged as having, committing plausible genocide in Gaza, it also creates potential liability for other states because the Genocide Convention creates complicity in genocide as a separate crime, which means that these states that are politically or supporting Israel otherwise through military support, they may be complicit in a genocide that's happening. So if those states had to remove that military support, it would be very difficult for Israel to proceed any longer, all right? So I think that's the one significant thing. Coming off the back of that order, I think there will be considerable pressure on the International Criminal Court now. How long will it take? Remember, the International Criminal Court's been investigating the situation in Palestine for years, and the needle hasn't moved. But now that the ICJ has issued the order for provisional measures, and it did so quite quickly, the matter was heard, the application was heard quite quickly, the order was delivered quite quickly, the prosecutor of the ICC may be under pressure to act. And this will also encourage other states, Chris is talking about a change that we want to see in international law. It may encourage other states that until this point haven't wanted to come out and address the conflict in direct terms to do that. And so how can a potential judgment be enforced? What the provisional measures or any potential judgment coming out of the ICC, for instance? Again, I think that the way we have to handle the conflict in Gaza is to really look at who is involved in the conflict and what it would take to stop that military campaign. Thank you.
I'll take 1 minute. I just want to explain just one thing. Maybe I have my students watching online, so I can't live without explaining this. And there is a difference between the International Court of Justice and the International Criminal Court. The International Court of Justice is the one that deals with the disputes between states, such as the South Africa-Israel case. And then the ICC is about individual criminal responsibility, meaning that those who participate in the atrocities will have to be brought before the ICC as individual, not as Israel as a state. So Israel will be dealt with at the ICJ, while ICC will be the ICC will deal with individuals. So those who directly participate or those who direct their participation can be brought before the ICC. And then when it comes to the judgment of the ICC, it will be easy. If somebody is found guilty, then they go and sentenced to jail. The ICC does not have a jail, but it can talk to states that can put up their hand to take on the people. And then the ICJ, the judgment on contentious issues will be binding, obviously. But the question is, implementation really is not necessarily about the ICJ giving that judgment. It's about the implementation, and people have been talking about how these provisional measures judgment is going to be taken. And it goes to the Security Council, and the Security Council would decide. Somebody in the morning said, hopefully nobody is going to veto But obviously, the General Assembly, with its limited powers, can also deal with that, which can mean that if the majority of the General Assembly wants to issue some sanctions, etc., that can happen. I just wanted to clear that up, between the difference between the ICC and the ICJ. Thank you.
Max, do you have any last words to share?
I have a last word, but which goes back to the first question asked, and about reimagining international law and trying to, despite all of the inbuilt and in-baked difficulties with it, to recognize that there's a lot, I think, that we can celebrate. As a country, for instance, I think there's something to celebrate in the fact that we speak about jus cogens, and Chris highlighting that jus cogens is really an animating feature of international law that has been pushed very hard, and including ultimately by African states. And the most recent UN Special Rapporteur at the International Law Commission on the topic of jus cogens was a South African, Professor Dire Tladi, who next week is being sworn in as a judge of the International Court of Justice. And that's a reimagining of international law in its own way, and a powerful demonstration of how I think it is a space in which lawyers and South African lawyers and African lawyers can increasingly make a difference and play a very important role.
Chris, you're good. So that brings to an end our panel. Thank you very much to our esteemed guests and to our audience who were very patient. You're going to be refreshed in a moment, and we will try and start as promptly as we can. We are now running late by 15 minutes, so we'll probably start in about 10 minutes. Just stretch your legs and then we'll commence again. Thank you.
Okay. I think we're ready to start. I'll just talk while Kurt adjusts the sound. Kurt? It's singing a bit. Right, welcome back, everybody, for our final session of today. Can you turn it down a bit? We've traveled a journey together. We started off with the diplomatic response to the occupation of the territories, the Palestinian territories, and the conflict in Gaza flowing from the 7th of October. We then looking at, terrible, I need a longer arm. We then moved to looking at the international legal framework and set of issues pertaining to these actions. Our focus now in our final panel is on the humanitarian response both to the occupation as well as to the conflict in Gaza. We're going to be looking, the speakers that we have invited to join us now will be leading and giving information on the role that civil society organizations have played in that humanitarian response. So the role played by CSOs not only in the interventions that they've implemented on the ground in Gaza to mitigate some of the suffering flowing from the conflict in the region, but equally interventions that they've put in place in solidarity with the people of Palestine. So both the humanitarian response, acts of solidarity and networking by civil society organizations, and equally importantly within our conversation of the international legal response to this context, speaking to the contribution that civil society organizations have played to that international legal response, to the diplomatic efforts, the measures and interventions to raise awareness about the extent and the impact of the suffering of Palestinians, their interventions to demand a response from the international community, and their policy advocacy and mobilization work that they've undertaken. So we're very proud and delighted to have with us Dr. Imtiaz Sooliman, a South African celebrity. He's been inundated by me and other people wanting selfies with him. He is a former medical doctor. He's the founder and director of the South African Gift of the Givers. Since 2002, Dr. Sooliman and his team have been working in the Eastern Gaza Strip with through a childcare center, providing aid to the people of the region in the form of food and medical supplies. We will start off our session with a short video that Dr. Sooliman has brought just to demonstrate some of the work that they've been doing. We will then follow on with Thandi Matthews, who is a lecturer in Law and Development Studies at the University of Wits. She's also an attorney of the High Court of South Africa and comes from our human rights institution. She was a senior researcher on civil and political rights and a senior legal officer at the South African Human Rights Commission. We will end off then with my colleague from UKZN, Dr. Lubna Nadvi, who is a political scientist. She's a senior lecturer here at UKZN. Her focus is on politics and international relations. But importantly for this conversation. For the past 3 decades, she has been active in works of community development and involvement. But since 2003, so 20 years ago, she was appointed as the Education Officer for the Palestine Support Committee of Durban. And she's been the co-coordinator of Durban's anti-war movement, the Durban chapter of the anti-war movement, and she's a co-founder and executive member of the KZN Palestine Solidarity Forum. So we'll start off just with a brief video introduction, just that will help frame and understand the work that is being done by Gift of the Givers, and then we'll move on to Dr. Suleiman.
Thank you very much. The Women and Child Care Center does not exist anymore. It's bombed. The kindergartens for the kids has been bombed. The Child Care Center in Khoza has been bombed. And one of the 3 desalination plants has been bombed. In addition, my head of office, who was a pharmacist, and his brother, a doctor, were both murdered on the morning of 16th November, coming out from Friday prayer, from morning prayer. They got struck directly by Israeli forces, and both of them were killed. And in addition, my other staff members that I have, inside and outside Gaza, collectively, they've lost 150 members. One of my team members, her name is Aya Jabbar. She is in South Africa. Her family were killed. In Gaza, they live in apartments. So like a whole block, brothers, sisters, uncles will live in the whole building, each one in a separate apartment. So Israel directly targeted one of the buildings and 50 members were lost. On the 4th of December, I brought her to Cape Town and she addressed 100 journalists on the situation of her family and what happened to them. 2 days later, on the 6th of December, her stepfather, as he was stepping out of the house, was killed by a sniper. It's almost as if, because you spoke, we're going to teach you a lesson. The next day, her mother's sister, the mother's other families, the uncles, the grandfathers, the children, 50 of them living in an apartment were bombed, and the other 50 were killed. Some of them were under rubble, and she had that stress for many days that the rest of her family is not going to survive. She was terrified for her one sister who did not live there. We managed to move that sister. That's the only surviving relative she's got. She's now in Rafah. My head of office, Ahmed Abbasi, when he got bombed, I just come out of theater. And to me, the most important thing was to move him, to move his family to safety. Now, this is a very strange story. On the 11th of November, I was doing a video interview on a mosque committee in Cape Town. A few days previously to that, Ahmed Abbasi spoke to my team members who keep in touch. It's not easy to keep communication because of the network. And for some strange reason, on that 11th, I had a premonition that something's going to happen to him. But before I had that premonition, he had that premonition. He told my team members that, no, I'm not moving around anymore. They keep telling us to move from here to the other side, and they bomb you as you move. We're not going to do that. We're going to die in dignity as non-military martyrs. I'm going to stay in my house. I'm taking my wife, my 3 children, and my 30 family members, and we're going to stay in our house in Gaza City. And we're going to wait for the bombs to fall and die in dignity rather than run around and be displaced and don't know where you're going. But I will do my job as gift of the givers. I will do my job to serve the people as best I can. And on the 11th, when I was doing that interview, I had this terrible feeling that something's going to happen around day 40. And November 16 was day 41 in the morning that he was killed. In the week of 7th October, when we saw what was happening, we people in disaster, we specialize in disaster, and we always take notice of all the things that happen. And immediately I sent a message. It's a horrible message to send, but I'm in the business of saving lives. So I told my guys, tell them, expand the team, get more networks, get into more areas, because we are going to lose team members. There's some of you are going to die. And that happens, the people of Palestine are not going to get support. So unfortunately, as terrible as this message sounds, it's a realistic message that you've got to take precautions. They smiled. They smiled, and they said, don't you think we know where we live? We've already done that. We've already expanded the teams. We've got networks, and no matter what happens to any of us, the work will not stop. And true to their word, 115 days have gone. The work has not stopped. We have access to move bank money into Gaza, but no issue itself. We've been involved in Palestine since 2002. That was the very first mission that Aziz Pahad and myself traveled to the West Bank, to Ramallah. He went to see Yasser Arafat on behalf of the government. And that was our first complicated mission to get medical equipment into Ramallah. The Israeli embassy did everything possible to tell the world they're allowing things to go in, and did everything possible on the other way to block us taking the medical equipment in. But fortunately, after 12 weeks, we broke their campaign. They couldn't fight us anymore, and we managed to get the items, together with the South African government, into Ramallah. Then there was a big break. There was not much intervention in Palestine. It's such ad hoc support maybe during the month of Ramadan, nothing major. 2009, when the war came, the attack on Gaza came, it's the first time that we took in medical teams, medical equipment, and supplies. We went in with 40 medical personnel, with doctors, and for the first time, it's a long history about gift of the givers, but for the first time, we had trauma counselors. And also we took media into the area. The trauma counselors had the unusual experience, where all they saw were planes, tanks, artillery, bombs, dead people. That's what the children drew. Nothing about happiness. Kids supposed to be happy. But these kids only drew death and destruction and bombed out buildings. And as a result of that, can you hear me? As a result of that as a result of that experience, we're not now preparing, we already have prepared. Medical teams, there's 200 medical personnel on standby of every known discipline in medicine. Because in essence, Gaza is now, in essence, it's not working. You got another mic? Also not working.
We need to put it on.
Where is it? Yeah. Every discipline, because Gaza is a wasteland. There are healthcare workers that are there. Many have been killed, have disappeared, have been kidnapped, are exhausted, and the institutional knowledge of the best brains in Gaza are gone. They're killed. They've been deliberately targeted. So you need to send in replacement medical knowledge, and you need to send in replacement manpower. So even a simple thing like a dentist, a primary healthcare nurse, ophthalmologist, optician, and the more complicated stuff, general surgeon, neurosurgeon, orthopedic surgeon, anesthetist, and all that kind of stuff you need. But more than that, you need trauma counselors. And what we've done, my wife is a counseling psychologist. She has been in the psychology team in the organization. She's been in touch with various groups all over the world, especially with the Palestinian Ministry of Health, those that deal with mental disease. You see, you can't go and impose your way on another people. As part of disaster management, you integrate into their system. You fit in with what they know. Because we come in very clever South Africans, and we can put in a system in place for 10 days, and when we walk out, what happens? The whole thing collapses. So you always ask advice in disaster intervention. And they said some of the techniques that you guys are learning and want to employ is not going to work. And as a result, counseling teams with the organization have been training on specialized courses. Courses that cost $7,500 to $10,000 each, but they've been subsidized or been given a discount, and these people are paying their own money to go through this training so that they could be active volunteers when the door opens up to walk into Gaza. Well, that's part of the future planning. But disaster could happen the same day. What do you do then? On the 7th, after the event happened, I phoned them. I said, do you know Netanyahu's ego? This man is going to go crazy in what he's going to do inside Gaza. Make sure you can get all the wholesalers, all the supermarkets, all the pharmacies, anything you can get your hands on, buy the stock and put it away. You guys are going to need supplies to an extent you've never dreamt in your life before. It's going to happen. He's going to go insane. And that's exactly what happened. We managed to get stock. We bought from everywhere. Our name is big in Gaza. Everybody knows us. Because in 2009, when we went in and took in teams, we went again in 2014. We supported them in 22 and 21, and again now. So we're well known. So we bought the supplies, and our team started delivering. Simple, basic stuff. Medicines, medical equipment, food parcels, warm clothes, hygiene packs. So those who were getting bombed were not coming from the house. They were coming straight from wherever they were to the hospital. They had no backup supplies. The homes were being bombed. The streets were being bombed. So in the hospitals, we were supplying medical equipment, medicines, wheelchairs, hygiene packs, food for the hospital itself. At one stage at Nasser Hospital, we were paying the staff. There was no money. So to keep them going, we started paying the staff, more than 100 staff, just to have some money for themselves. With the UN camps, we were working and provided 4,000 to 5,000 hot meals a day. And then in broken homes, not homes, broken homes with no home, everything's destroyed, we delivered food parcels to old people. Fuel became a problem. We managed to get fuel and supply the ambulances to the extent that we could get the fuel. When the electricity got cut off, our desalination plants collapsed. We had 3 desalination plants. But the people of Gaza came forward, brought generators, and brought fuel from their cars wherever they had fuel. So we had the fuel to run the generators, to run the desalination plants, till one of them got completely bombed and destroyed. The other 2 were working while there was fuel. And we got our own water tankers, but it also requires fuel. Eventually, we started using donkey cart. Not to use fuel, so we used donkey cart to move the water wherever we could. People came walking, and they came on bicycles and any kinds of means to come and take the water wherever they could take the water to. And that was what's happening up till day 60. On day 60, we ran out of supplies. You couldn't buy stuff, but you couldn't move because the bombs were falling everywhere. And in the first 10 days, when I asked my teams, like, what is your experience? They said, nothing like we've ever experienced before. On day 10, they were using the word genocide. They said, this is genocide, this is massacre, this is mass killing, this is major displacement, targeted killing, and indiscriminate bombing of hospitals, schools, institutions, mosques, everything. Total destruction. How are you guys managing? We have to do this for our people. What about your families? We don't know where they are. We don't know if they are alive. But we have to do this for our people. This is what Palestinian resilience and resistance is all about. And every day I get up, I'm thinking, when we phone, is it going to say they're going to answer the phone, or they're not going to answer the phone? Are they going to be alive? Are they going to be killed? And amazingly, we've lost only one of our staff up till now. It's an absolute miracle. But unfortunately, the other members have lost 150 family members, as I mentioned earlier. In any case, within the first 10 days, I met the foreign minister, the Durko, Naledi Pandor, I met Zain Dengo, and I said, we're going to start preparing to sending supplies in. An entire team was put together at Durko to meet us. I met the Egyptian ambassador the same day. I know the drill, because we've done the system before. The system is very clear. There is only one route. The government has to give a letter of support from South Africa. The embassy in Egypt has to give a backup letter of support. The Egyptian government has to acknowledge it, accept it. The Egyptian Red Crescent got to collect to say, yes, they're going to take the stuff. They're the only people in the world allowed to take items into Gaza. It has to be received by the Palestinian Red Crescent on the other side. So we met all these entities along the way. The Egyptian Red Crescent doesn't have its own trucks. You have companies that have trucks. You have companies from which you're going to buy the supplies. Fortunately, the pricing was good in terms of the trucks and the supplies and the items. But then you can't take certain types of medication. You can't take tents though it's raining and pouring. You can't take fuel. And you can't take some other kind of supplies. If one item is incorrect in the truck, the entire truck is sent back. And there's a policy of messing around and saying to the public, we allow trucks to go in. Our first 3 trucks took 20 days to get in from Cairo into Rafah. To cross from Rafah inside Gaza, a journey of 30 kilometers took 13 days. So it's from Cairo to the Rafah border, to Karim Shalom, to the Israeli side. They keep the trucks for 2 or 3 days. They decide when they're going to leave it. Then it comes back to Rafah, goes to the X-ray machines, and it goes into Qatar House. Qatar House is a building where the UNRWA and the Palestinian Red Crescent supervise the offloading of the trucks. But there's a catch. The Palestinian Red Crescent doesn't have enough trucks. They don't have enough manpower. They don't have enough fuel. They don't have enough storage space. They can't move on all the ground easily. There's bombing everywhere. The roads are destroyed. It's damaged. It's high risk. You can't move anything to the north. My teams were highly depressed. There were almost 800,000 people in the north, all calling for water, for food, for medical supplies, for heating. There was no way we could move. You move, you get shot by a sniper, or a tank blows you up. So there was a no-go zone. So we knew they were there, but there was nothing we could do about that. And we managed to get 3 trucks in. Last week, we managed to get another 8 trucks in. We're preparing for more trucks. The first 3 was a trial run to see what happens. The second 7 was a little more. 8. And now we're preparing for more trucks. But to us, the biggest benefit is going to be when we can take human personnel in. Even want to take lawyers to record, to be witnesses for crimes against humanity. We've spoken to the legal team in South Africa to take Netanyahu to the ICC for killing my office staff, his brother, and 150 family members. We've given evidence, and we can get much more evidence from many Palestinians. And the question I was going to ask is, and maybe the lawyers can answer afterwards, can we charge Netanyahu and Israel for war crimes and reparation? That they're going to rebuild everything they destroyed, got to compensate every person they killed, and for psychological and emotional trauma to every person that suffered in Gaza. We need to charge them for that. I don't know how the rules work, and whether we can apply it, but if that can, we'll be the first to do that, to charge them. Thank you.
Thank you, Dr. Suleiman. I think that puts into context the reality that we have to confront. As many have noted, this case has put on global record the dehumanizing experiences of the Palestinian people, and our laws in so-called liberal democracies have been weaponized to perpetuate the violations of fundamental human rights. More than that, we speak of the erasure of entire peoples, cultures, and histories that speak to our global humanity. For the past 75 years, Palestinians have experienced daily acts of humiliation and indignity, checkpoints, harassment, permits, bus and beach segregation, walls approximately 8 meters high and more than 700 kilometers long that separate families from each other and their land. In the Palestinian context, as a consequence of the absurd combination of settler colonialism, apartheid, and illiberal democracy, the law serves as both a sword and a shield toward the advancement of social justice, but it is also a sophisticated tool to legitimate the continued oppression of women, men, and children. As we have also seen over the past few months, this backlash extends to those who express Palestinian solidarity in countries that purport to promote democratic freedom and values. For example, under the guise of state securitization, many Western countries have banned pro-Palestinian marches and symbols expressing support for Palestine on the basis of violent outbursts or anti-Semitism. Employers have suspended employees for pro-Palestinian content on their personal social media accounts. Students have been prevented from holding academic debates on the issues at university campuses, and individuals have faced threats of defamation. The purpose of these measures has been to silence all forms of dissent, and those most affected have been all that challenge the dehumanizing implications of racism, patriarchy, and neoliberal inequality. Indeed, none of us are free until all of us are free. What we see today is not the first time that these atrocities in form and substance have occurred in Palestine and Gaza in particular. Most recently, as documented in South Africa's ICJ application, during the 18-month-long peaceful protest of the Great March of Return that took place along the separation fence between Gaza and Israel, 214 Palestinians, including 46 children, were killed. Firing behind the separation fence, the Israeli security forces killed and gravely injured civilians who were neither participating directly in hostilities nor imposing an imminent threat to life, including children, paramedics, journalists, and persons with disabilities. It is therefore to be expected that those most in need of the law's protections are losing faith in the notion of human rights, the rule of law, and the integrity of public institutions, institutions of governance to advance social justice, both in the international and domestic contexts. It is also not the first time that South Africa has utilized global governance structures of liberal internationalism to generate international solidarity to combat apartheid, as one of the South African liberation movement's 4 pillars that included mass mobilization, armed operations, and underground organization. In addition to the role that South Africa spearheaded with respect to the Convention on the Suppression and Punishment of the Crime of Apartheid, it was the death of Steve Biko in 1977 that led the UN General Assembly to develop and adopt the Convention Against Torture. And in 1997, the General Assembly resolved that South Africa would host the World Conference Against Racism, Racial Discrimination, Xenophobia, and Related Intolerance, which was held here in Durban in 2001. The ensuing Durban Declaration and Program of Action provides a comprehensive framework that aims to combat racism in all of its manifestations. There is a distinct correlation between racist and xenophobic rhetoric and ensuing genocide. As referenced in South Africa's application in December 2023 under its early warning procedures, the UN Committee on the Elimination of Racial Discrimination warned of the deep implications of hate speech and dehumanizing discourse targeted specifically at Palestinians, thus raising severe concerns regarding the obligations of Israel and third-party states to prevent crimes against humanity and genocide. Indeed, as highlighted repeatedly by Dr. Naledi Pandor, in South Africa and on the African continent, we know too well the implications of dehumanizing language in facilitating the continued oppression and erasure of the dignity of peoples deemed unworthy of exercising their full humanity. In Rwanda, over just 100 days, close to 1 million people were massacred before measures were taken by the international community to stop the killings. Coincidentally, I was in The Hague on the day that the ICJ delivered its provisional measures, and while many protesters that I met were disappointed that the ICJ ruling did not call explicitly for a ceasefire, almost every international lawyer, and especially citizens of the Global South that I encountered, spoke to the importance of South Africa as a defender of international law. This case goes to the heart of the establishment of international law post-World War II, and liberal internationalism as currently conceptualized. There appears to be a growing recognition that notwithstanding their physical location, global institutions of governance belong to all of us. whether they are located in Geneva, New York, or The Hague, including those of us in the South who are deemed to be on the periphery of global decision-making powers, irrespective of the veto limitations held by powerful states or the lack of enforceability mechanisms to ensure that states adhere to court rulings. As expressed by Prof. Max earlier, the ICJ application represented equality, legal objectivity, the repudiation of South Africa's case as meritless, and importantly, that the law counts. What was demonstrated throughout this entire process was the crucial role that civil society plays to hold states accountable to enforce their legal obligations. The persistent documenting of human rights violations by civil society actors, including journalists and ordinary citizens, through alternative social media sources to preserve evidence and feed information to official UN bodies was integral for this case's success. Not only was this information relied on by the international organizations referenced in the case, it also informed the provisional measures that were issued by the ICJ. This was even more important where independent bodies and international media were repeatedly denied access to conduct independent investigations in Gaza. International media were also subjected to the limitations of being embedded with the Israeli army and when they could access the Gaza Strip, which significantly impacts the narrative of how perspectives are shaped. In this respect, the ICJ ruling demonstrates the effectiveness of people's power. For example, despite many mainstream media outlets failing to live stream South Africa's ICJ submissions, during the judgment, which was widely accessible, the judge-president read into the record South Africa's claims, including statements by Israeli officials, which may be construed as inciting genocidal acts. These include statements made by Israeli Defense Minister concerning the delivery of humanitarian aid to Palestinian people he referred to as human animals, the President of Israel who invoked the idea of collective punishment, and the Israeli Minister of Energy and Infrastructure who effectively called for the elimination of the entire civilian population in Gaza by denying them water and energy. Beyond the ruling, it thus becomes vital for civil society to frame the narratives in how human rights violations are described and to hold all states accountable to the obligations as per international law, and particularly with respect to the Genocide Convention. Additionally, the ICJ ruling emboldens those who continue to confront reprisals for expressing pro-Palestinian sentiments, thereby ensuring that ordinary citizens across the world collectively advocate to protect their rights to assembly, protest, expression, and access to information. Lastly, the law does not operate in a vacuum. It is one element of a political strategy that requires consistent mobilization to ensure that the state demands are in unison with those of civil society. Indeed, there must be a ceasefire, but it will take more than the law and court rulings to achieve this ultimate objective. And as we were reminded by Prof. Zozo earlier, all of us have a duty to defend and protect our collective humanity. Thank you.
Sanbonani, good afternoon. Thank you very much to the organizers of the symposium for this opportunity to reflect on the role that civil society has played in terms of Palestine solidarity work. So I'm going to use this opportunity to reflect on some of the historical aspects of that, and so take us back a bit, if that's okay. And of course, as my age shows, I need to wear reading glasses. So it's precisely because of the role played by civil society and non-state actors, both internationally and globally, that Palestine has been so prominent in the global arena over the last 75 years and continues to remain so. Where governments and international bodies, like the United Nations, have failed to carry out their responsibilities in terms of international law, it is the millions of people that have come out on the streets, marched, demonstrated, occupied buildings, and boycotted, amongst other actions, that Palestine has not been forgotten. It has been the Palestine solidarity organizations and fraternal bodies that have organized solidarity events, commented in the media, and used social media in various ways to expose apartheid Israel and its crimes. This has been the case particularly after the events of the 7th of October 2023. The global civil society space has had to be creative in ways that one could not imagine in order to respond to the manner in which Israel has used the impunity it is afforded by the international community to continue to attack Palestinians in Gaza, the West Bank, and Jerusalem. It has in particular been because of the bravery and steadfastness of the Palestinians themselves, who have spoken out at great risk to themselves within the Palestinian territories and in the diaspora. And of course, I think we've all seen these videos of journalists like Motaz and Bisan and others who have basically been sharing what's been happening on the ground. And so, it's very important for us to commend the work that they have done in bringing the reality of what's been happening in Gaza over the last 4 months. We've all seen the pictures over the decades of entire streets in cities across the world being taken over by masses of people marching in solidarity with the Palestinians, making 4 specific demands. Firstly, end the occupation of Palestine. Secondly, allow Palestinians the right to political self-determination. And what form this will take will depend on the Palestinians themselves. There's been this huge debate about 2-state, 1-state, and what's important for us to remember is it's up to the Palestinians themselves to decide what political arrangements they would like. Ensure the right of return, and this is another debate, and I'm sure our legal colleagues would also be reflecting on this issue. And of course, boycotting apartheid Israel. And this is a very important aspect of the work of civil society. Solidarity has, however, taken many forms other than street protests. For example, artists globally have really used their creativity to illustrate solidarity, from the visual arts to music, dance, film, theater, political cartoons, to various other forms of digital art. Artists have captured the narrative of what Palestinians have experienced from 1948 till today, and of course the struggle itself. Celebrities have made statements in support of Palestine and refused to visit Israel to perform. And here in South Africa, for example, we've called on many of our South African artists to not go to Israel. But of course, some have refused to listen and, have gone. So we've had challenges in that regard. Many sports stars have also taken the same stance. So I want to, though, now move to looking at some of the historical aspects of the contribution of civil society, because I think it's important for us to reflect about where we've come from. It's really been from the 1970s that Palestine solidarity activism in South Africa has had more of an organized form. The Muslim youth movement was one of the first movements in the 1970s to engage around Palestine solidarity in South Africa. And while it was primarily an organization for providing a space for Muslim youth to attend things like training programs, develop and engage with each other for broader society, it considered Palestine a key issue to incorporate into its programs and has continued till today. Subsequently, other groups such as the Muslim Students Association and Qibla also took on the issue of Palestine in a more organized way. And of course, this is going back to the 70s and 80s. The formation of the Palestine Solidarity Committee in Joburg in 1998 created a space which consisted of both Muslim and non-Muslim membership. And this is important to note because Palestine solidarity is a human rights issue. It's not just about one religious group. And that's why that formation of that Palestine Solidarity Committee was so important, to take the issue of solidarity to the broader community. And it became a broader secular social justice campaign which included everyone who wanted to be involved. The PSC also provided national leadership in terms of creating a South African declaration on Palestine, articulating a clear South African position on Palestine, particularly on the similarities between apartheid South Africa and apartheid in Israel. Subsequent to that, the formation of the Palestinian Solidarity Committee in Cape Town in 2001 and the Palestine Support Committee in Durban in 2001 also undertook to pursue a secular, inclusive agenda which enabled wider participation. All of these groups included involvement from broader civil society, such as political activists from all backgrounds, trade unions, women's and youth groups, religious formations, sports groups, and in particular, progressive Jewish South Africans who rejected the project of Zionism. And this is an important thing to also remember. We know, for example, prominent South African Jews like Ron Castrol, who have been very articulate and outspoken and in support of Palestine. The formation of the National Consultative Forum on Palestine in 2001 was particularly significant as it worked to create a space where initially Muslim and then subsequently all groups could engage to consult with each other around Palestinian solidarity. The hosting of the World Conference Against Racism, which has already been mentioned, in Durban, and its impact in creating the impetus for building a stronger Palestinian solidarity national movement cannot be understated. And this is why, because at that time, the United States did not want the issue of Zionism to be discussed on the agenda of the World Conference Against Racism. However, because of the mobilizing of local groups working together with the NCFP, Zionism stayed on the agenda, and the term Zionism is racism became a key phrase from then on. The United States and Israeli delegations eventually pulled out of the World Conference Against Racism because of the very strong pro-Palestine solidarity that was displayed. And of course, Yasser Arafat had also attended that conference along with a very strong Palestine NGO delegation. And together with that Palestine NGO delegation, I was present at that conference, so I can reflect on some of these things. We committed to ensuring that Palestine will remain on the international agenda and it would actually become a global campaign. So in Durban, for example, the role played by groups like the Durban Social Forum, which was made up of organizations like the Concerned Citizens Forum, Jubilee South Africa, and so on, were very significant because, locally, that is the work that was done on the ground that actually made a huge contribution. And there was a march of about 25,000 people at that conference that actually took the issue of Palestine forward. Of course, there were other, delegations focusing on other issues at the conference, but Palestine became the main issue. In 2005, the BDS National Committee was set up, and it serves as the international body advancing the cause of boycott, divestment, and sanctions, also known as BDS globally. Around 2006, BDS South Africa was started to advance the BDS campaign in South Africa. It worked to coordinate various national campaigns, such as Israeli Apartheid Week and the Boycott Woolworths campaign, amongst others. If you participated in those, you would remember it. It also subsequently evolved into a group called Africa for Palestine. More recently, a new structure called South Africa BDS Coalition has formed to continue with various BDS campaigns and works with a variety of organizations nationally to advance BDS work in South Africa. And I've mentioned BDS because this is a key aspect of civil society work. Boycott, divestment, and sanctions, in the same way that sanctions worked to bring down apartheid in South Africa, that is a campaign that is so important to bring down apartheid, in apartheid Israel. So since 1998, many new formations, which are particularly dedicated to Palestine solidarity, have formed nationally. And while structures like the Durban Palestine Support Committee and so on don't exist, other structures have formed to replace them. And I mention this because for those of you who are interested in joining the KZN Palestine Solidarity Forum, for example, or other groups, please come and talk to me afterwards. In addition, formations like trade unions, political parties, and religious bodies whose core business is actually not Palestine, but they have included Palestine as part of their ongoing programs, and that's also very important and significant. For example, the Christian, national organizations, the church groups, and so on. So this is a very important aspect of the work. Because we are at UKZN and I'm mindful of time, I just want to reflect on our role as students and staff. Since 7th of October, we have obviously, as activists here, based here locally in KZN, been taking on campaigns, we've been doing a lot of solidarity work and a lot of activism work. And we've also organized within UKZN, and we have a UKZN Palestine Solidarity Committee, and we hope that that will now grow and strengthen, of course, based on all campuses across the university to take solidarity work forward. Let me be bold and say, those of us who are, who've been involved in Palestine solidarity work have adopted a full boycott, academic boycott of Israel. For example, we don't engage with Israeli academics, we don't visit Israeli universities, we don't do research with Israeli entities. But of course, it's important to distinguish between pro-Palestinian Israeli colleagues and of course those that support the apartheid state of Israel. What I'd like to end off with is putting out a challenge to my colleagues and to our university management at UKZN to put out a very strong statement, firstly in support of Palestine and to condemn what Israel is doing, and of course to adopt fully an academic boycott of Israel. And so I encourage our Vice Chancellor and our management at UKZN to do this, and I'm hoping that this year we will see a full academic boycott of Israel and that we can then announce it. So that is the challenge I'm putting out to our colleagues and to our management. And I'd like to end off by saying that we've been doing a lot of work around Durban to put out the messaging of Palestine solidarity. One of the ways that we've been doing this is through painting murals. And I want to end off my talk by showing a little video of a mural that we did last year in December, which is on the corner of Curry and Springfield Road. So our international guests, please do go down and have a look at it. And so can we play the video now? Thank you so much. It's not playing? Oh dear. Yes, sorry. Thank you.
Perhaps while we load that video, and first of all, thank you colleagues for those preliminary remarks and for painting really such a vivid picture, not only of this historic role of the solidarity and support and involvement between South African civil society and Palestinian civil society, but the immense developmental aid and humanitarian support, particularly now and at this time of crisis, and at such great personal cost to the people who are rolling that out. I wanted to ask our colleagues if we can consider now, in this moment post the court ruling on Friday, the particular role that you imagine for civil society organizations now. We were encouraged by earlier speakers that it is upon us, I think you might have even made the point, it's upon us to hold our states accountable for ensuring that the provisional measures and orders of the court are implemented and that the states uphold their obligations in terms of the Genocide Convention. We heard about the particular and crucial role that civil society organizations are playing in documenting evidence and capturing very specific information of the atrocities that are being committed that can feed into criminal cases down the line. So do you want us to pause and play now? Are you ready? Okay, let's take the video. You can think about that.
القدس وعكا نحن إلى يافا في غزة نحن وقلب جنين الواحد منا يزهر آلافا لن تذبل فينا ورقة تين ما هان الحق عليك ولا خاف عودتنا إيمان ويقين لن نسكت لن نستسلم لا 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 لا, لا نفديك لنحيا يا فلسطين فلسطين بلادي نحملها جرحا أو أملا لا 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 لو راح نبقى فيها اليوم الدين.
Thank you. Okay, what critical role can we play as civil society now, post the ruling of the ICJ, with the pending opinion that is and the public hearings that are set to unfold, to play this critical role? Would you like to start off?
Well, I think for me, I think the important thing is to educate ourselves about the different roles and responsibilities of the various institutions of governance. I think it's important that we understand how narrative shapes outcomes, and that if this forms part of a broader political strategy, how are laws being used domestically to prevent us from exercising our rights and freedoms? In the Cape Town context, for example, when it came to murals, some communities were told that they couldn't paint on their walls, and communities resisted in that respect. So I think we need to constantly be aware of how our individual rights and freedoms are being minimized, but also to be bold, to be able to claim those rights on our individual terms. I think something that has been very apparent for me, last week I was in the Netherlands, and this was a very difficult conversation to have. It wasn't only difficult because of the polarized views, but also if you're not using the right language, you get dismissed very quickly. I think in the South African context, it's a much warmer, dynamic conversation for us to have. And I think it's something that we really need to mobilize around, and to have more of these conversations in spaces that we think don't require that conversation. So it requires ongoing mobilization. We know that this case is going to take a very long time. Ending occupation in Palestine is going to take even longer. And so I do think it requires constant mobilization, and to also understand the real economic costs, Dr. Suleiman, that you spoke to. How much money is being donated to Gift of the Givers from ordinary South African citizens that is just getting lost in bombings. So I think the more we understand how we are all connected in this global context, empowers all of us to continue in the mobilization.
So one of the things that the Palestinians have asked of us is to not stop talking about Palestine in every way possible. So whether you're a medical doctor or whatever professional you are, an academic, if you're a student, if you're a journalist, a lawyer, whatever the case might be, don't stop. If you're a Palestine Solidarity activist, and even if you haven't really been involved in Palestine Solidarity, make the effort to do so. Because what are we as human beings if we do not make that effort? We've all seen the visuals of what is going on in Gaza and what's been happening for the last 75 years. So I would say that don't stop talking about Palestine. And this is what Israel is afraid of. It wants, and it's been doing everything possible to try and silence us. It uses, its allies and everyone that supports it to actually try and silence us. Of course, on social media, companies like Meta are shadow banning the posts that we as solidarity activists are putting up. And we keep fighting back. So the most important thing is don't stop talking about Palestine and continue to fight back. It's taken 75 years for us to get here. And our South African government has taken a very bold step in doing what it has done. So I think that we need to continue with this work, and I'm hoping that it's not going to take another 75 years. I won't be around at that time. Most of us won't be around, but we hope that in our lifetime we will see a free Palestine. But it requires each one of us to not stop talking about Palestine. Thank you.
My sentiments are the same, but I just want to add a slightly different dimension. You see, when the bombing started, we got invited to set up a pledge line on a TV show. I told the guy, we don't do pledge lines. We don't need pledge lines. And I'm really not interested. But as a courtesy, okay, I'll do a Zoom from my house, and you can have the pledge line just to say thank you. And then 2 days before the pledge line, Al-Ahli Hospital got hit. And I said, this changes everything. And then I said to myself, what are we doing? 2009, they bomb, we take food, we take medical teams, you go and help. 2014, they do the same thing, we do the same thing, we go back and help. In 2023, we're going to do the same thing again. It's like the floods in Alex. Every time the floods come to the Yexke River, move the people, build houses, they drown, they go away, the flood goes away, they go back there, they drown again, they go back there, they drown again. Doesn't make any sense. And then I looked and thought about it, I said, what's the problem? And the problem is people don't know this conflict. I said the problem is we need to change 7 October to 75 years. That's where the problem starts. And now this is the ongoing of the same educational process. It's not 7th October. It's 75 years. And when you change the narrative, that's the first thing that had to be done, which we then did on the show. I said, forget the pledge line, let's educate the people. Which brings two teachings to us, don't mind. We have a teaching that the ink of a scholar is holier than the blood of a martyr. It applies physically and literally in every way in the situation. And secondly, the pen is mightier than the sword. That what can hold Israel back is the pen at the ICJ. You know, and that has made the huge difference. That we need to educate people. And we felt it in the ground. I'm a very blunt guy. You know, I say it like it is. But last week, or not last week, when your father was with us in St. George's Cathedral, when we had the memorial, Father Michael Wieder set up the memorial for Ahmed Abbasi in St. George's Cathedral. An African lady came, big-sized lady, and she hugged my guy, and she says, you know, I was always Israeli. Today I'm Palestinian. And we found that mind shift last week. About 10 people told us the same thing, all white people, in the streets of Cape Town. And on one of the videos, a white British man was speaking. And he said, my partner has been to all these marches in Britain. But with each march, the number of Caucasian white people like me is increasing. No point preaching to the converted, makes no sense. We need to win people who don't understand the concept. And this can't stop. It has to carry on. And to me, the biggest letdown is the African continent. You know, because we are regarded as the useless people, the backward, the hopeless people. And I say that because when I was in Pakistan in the earthquake of October 2005, northern country relief teams came. And they looked at us because they were confused. Because we got whites, Afrikaners, English, Hindus, Muslims mixed in the group. And they looked at us and they said, like, where are you guys from? We said, from South Africa. They couldn't understand it. So mixed like this from South Africa. Any case, that is by the way. Oh, you're from Africa. What did you come to fetch? You guys always hold the begging bowl. Always want things for free. Disease, conflict, backwards, poverty. And when we took the moral high ground, Africa should have jumped at that to say, the African Union and 54 African nation states say, yes, we don't need money to be on top. You see, people not interested in money. Real people are interested in spirituality, interested in the moral high ground, interested on being on the right side of history. And that's why congratulations to the team. 5 of them are from this university. You know, congratulations to them that they make an incredible impact, not for South Africa, not for Africa. They did it for humanity. Because are we going to stop? Are we going to stop at Palestine? Or if something like this happens again in the future, are we going to stand for humanity? And that's why education, changing of behavior, not allowing people to do what they want is important. And the last point, I spoke about, you know, educating the people, the pen. To me, the most important thing is that Israel has never been opposed. They bully people, they shout at you, they scream, everything's anti-Semitic. I'm scared to eat a watermelon now, and maybe anti-Semitic too. You know, it's that kind of thinking that they just put pressure on you all the time. And we needed to break that. And South Africa said, well, we got load shedding, we got unemployment, we got criminal behavior, but we're going to take you to the court. We're not taking you to the court, we're taking you, America, UK, Germany, your friends in Europe, the Zionists, your corporate companies, all your academic institutions. How can a doctor institution in America say it's fine to carry on with the bombing? What kind of medical values you got? 100 doctors in Israel say it's fine to carry on with the bombing. There's something seriously wrong with humanity. And that's why this is not for Palestine. This is for humanity. We have to carry on and educate people, but we ourselves have to be on the right side too.
That's a wonderful segue. I wanted to ask something a bit more metaphysical in responding to our panel talking on international law. And Christopher spoke about this kind of pivotal moment in international law and asking whether South Africa was up for that challenge. And our Commissioner Madlingozi spoke about the transformation of the world order. He called for an imbuing of the spirit of the African Renaissance. He reminded us of having a strategic objective of anti-imperialism, anti-colonialism. And I wanted to ask you, particularly then in that light, what can our focus be as civil society organizations in building and transforming that new world order so that we Dr. Mbete painted that really bleak picture that is unfolding before us now. But what work in terms of consciousness raising among citizens, so not only educating and speaking about Palestine, but consciousness raising around issues of anti-imperialism, anti-colonialism, deliberation and raising questions on freedom, democracy, liberation in our own countries, and holding our leaders accountable for those violations and atrocities in other countries. What role, what challenge faces us as civil society in your view? Anyone? Yeah. Should we start with yes.
It's not so much about what's facing us. You see, we are the victims of imperialism and colonialism. We know that. It's not something new to us. What's important is what's happening in Western countries, where the new youth and the new generation are now learning about this. And if anybody's going to change the face of the world, it's going to be them. Because we're not the ones that created it. We were the recipients of it. And that's why you need the guys who started it to be stopped by their own people. And all these marches happening all over the world, those people are now being, the young people are exposed. They're not interested in this. I mean, Biden's own people protested against him. And we must not forget to say a big thank you for the Jews for a free Palestine in South Africa and throughout the world. The Achilles heel for Israel has been the Jews and the rabbis for a free Palestine who made big motions all over the world. And we say a very thank you to them because it's not easy to take, an easy road to take. Because I tell you what happened. Within 4 days of us speaking out loudly and strongly, editors of newspapers and Jewish people in South Africa sent me messages to say we can't do this. We as Jews are afraid of the Zionists. We're afraid to take them on. Thank you for taking the moral high ground. And that's why a very big thank you to the Jewish people who stood up, and in every march they did first. They're right in the front. In every single march in this country they did first. And they're doing it all over the world. So it's not so much about us. We need to be aware of what it is all about. But at the same time, the one point is our leaders should stop being taken by them and become proxies for these orders all over the world. Either you're in power to serve the people, or you're there for yourself. If you come for yourself, you better leave. And the only people who can change that are the citizens of our country, to remove those leaders who don't serve the interests of the people of the country and the continent, in this case, Africa specifically.
Oh, go on. No, you go, I'll go. So, just to follow on from that, we have to remember that we live in a world where colonialism never really ended. You know, we see sort of imperialist and colonialist things that are still continuing in various ways. And we actually have to be that generation. Of course, the younger generation, as you mentioned, they want a world that is different from the one that we are handing over to them. And it really made me so proud to see, for example, young American Jews that were taking over the Congress building in the United States. Never did I think that in my lifetime I would see that. So it is this generation that is saying, not in our name, and they really don't want this imperialist world that has been happening for generations. If you remember how the Palestine issue came to be, I mean, it started with the British handing over the land of Palestine when they didn't have any right to do so, with the Balfour Declaration. That legacy continues, and it continues in so many other spaces. So with this Palestine issue, we can actually change the world as a whole. Because in bringing about the change in terms of dismantling the occupation of Israel, of Palestine by Israel, we can actually dismantle a lot of other things. And as our legal colleague spoke in the earlier panel, they said international law is also sometimes hamstrung by those kinds of thinking. So I think that this generation will make the difference, and we have started. Let us continue with it.
Just very briefly for me, I've been very proud of our state, actually, and it's not common that as, in terms of rights-based methodology, being state-centric, that the state is often our target of frustration. In this instance, we see how collectively civil society and the state can work to advance a certain political claim, and I think it's very important to note that yes, I think our position when it came to, or the state's position on Russia-Ukraine was quite inconsistent, But I think having learned from those experiences, and our DG wrote about this quite openly, both on Twitter and in the Daily Maverick, considering how transparent the state has been from the outset on this position, and including all aspects of our structures of governance, passing resolutions through our legislature, engaging with the media, engaging with trade unions, engaging with civil society, when a lot of these decisions that were made could have been executive decisions without needing to be that transparent. I think that's something that we really need to start taking stock of, is the rise of the southern state in reclaiming institutions of governance that have been typically situated in the north. I think something that has also been very well spoken of or surprising in the global governance international legal space is how representative our legal team was. That we showed up as South Africans in all of our diversity, but unified in our approach to how we considered the framing of international law. All of these things are things that I think we take for granted as South Africans because we are used to our diversity and multiculturalism and also contestation that happens domestically. But internationally, it's totally novel. It's incredible how the lack of diversity exists in the global north in spaces concerning human rights. And so now to have the southern state decide and southern people decide, these are the terms upon which we are going to claim justice, for me that's been quite remarkable, and I think it's something that we need to be very proud of. Thank you.
Right, we do have some time still for questions, input, comment, observation from members of the audience. So can I just have a show of hands of people who would like to contribute to the discussion? I'm seeing two, our front row speaker and our colleague.
Thank you very much. Seyrun Sayed from KZN PSF. I just want to take this opportunity and say thank you to UKZN for this dynamic, meaningful, engaging symposium. But many of us seated here are pro-Palestinian or students, and I've already spoken to Chris and to Sheetal that we need to get into the broader space to talk about the research that have been done, the numbers that we have of people being killed, the terminologies that is used pro-Palestinian or pro-Israelis, death and that kind of thing. And I just see today on Instagram, the UK is considering recognizing the Palestinian state, and this is from Cameroon. So our engaging, our going out and talking about it will be making a lot of difference for people that haven't thought of it. And I've been involved in solidarity for all my life. But for the first time after the 7th, we see this number of people, especially in the north, that are standing up for human rights. On the second thing, I know there's funding challenges, but I'm just opening it up. Maybe we look at, we are 60,000 people, 30,000 in our country are suffering. If each one makes a donation of $2, one for our country, one for Palestine, and via the gift of the givers, we'll be able to make some contribution. We're looking at lots of countries are withholding their money towards this. But again, I just want to say there's a lot that we have to do as South Africans, especially winning the case, and it's our time to shine right now. Thank you very much.
Okay, greetings to all. Okay, my question is, I love what you said about, you said something, Uti, we're not even close to decolonization. I'm paraphrasing. Okay, so I like how you guys are all speaking about Palestine, but you are ignoring the issue the genocide that's happening in Congo. you've been speaking about Congo today, but very briefly, no one is going into details about speaking about it, how people are dying, how the Western people are still colonizing Africa, how they are still using foreign aid to to push their agendas, how there are still people dying there, and we all know that, I hope, but no one is talking about it. I know, you can't say, okay, Palestine is important, but also Congo is important, and I would like for us to, pay more attention to, everything. Let's focus on Africa, and then worry about, okay, I don't know. But I hope you get my point. I hope you get. Oh, another question is, it's about, I would love South Africans to answer this question for me. My question is regarding the elections, right? Okay, so we have three major parties, right? And we all know there's problems with the parties. But we all know, as the youth, I'm speaking of the youth, of why they're not voting anymore. We all know there's problems with these three parties, that's why we're not voting. So Jacob Zuma provided an alternative, right? And I think everyone is going to vote for him, the MK, because there's problem with the three parties. But we're all going to go there blindly, not knowing the ideology of the MK, nothing about it. Right? What do you guys think? What do we vote for this year, whatever? That's the question.
Who should we vote for? We're voting for Gift of the Givers.
Thank you. My name is Unomandima. My question is around, I think I want to echo your sentiment as well, around the role of civil society in as far as reshaping international law in the context of colonization. I want to expand on the point that Dr. Sthembile had made earlier about the greed of capitalism, right? Yes, we do approach, the question of Palestine, but it seems more on a humanitarian point of view. What radical approach that would change, because essentially, as Dr. Mbete had said, it's the greed of these multinationals, hence the United States is still funding Israel, right? So from a civil society point of view, what role then do you play to take a more bold and radical approach in ensuring that we actually do realize a free Palestine? Because if we understand the essence of why these territorial wars, including Congo, exist, is as a result of capitalism, essentially. So I think from a civil society point of view, because we've heard, the legal point of view, the diplomatic point of view, but from a civil society humanitarian point of view, and especially understanding the realities that are faced on the ground, what role then, radical, to be more emphasis, role can civil society then play in ensuring that it re-engineers the value chain to prevent any future form of colonization for the next generation to come? Thank you.
We'll take that one last hand, and then I'll invite you to comment. There at the back. Oh, there.
Hi, thank you. Thank you for giving me a second opportunity to speak this afternoon. It was a very enlightening symposium, and thank you very much. Some of the presenters have left, but under difficult circumstances for myself, I have managed to come here, and I'm glad I took the time out to be here. But with regard to civil society and educating our country and the world at large, what we need actually is we need our fellow South Africans from the diverse languages which we have. We know we've got 12 official languages, to start communicating this message about Palestine and about humanitarianism and about Congo and Sudan and about Yemen and about the work that they're doing to fight for freedom, not just for one country, but as I said earlier, every place where there's a genocide taking place or there's humanitarian loss or people are being abused, we need to stand up and speak. We can't just speak in English because people don't understand. Sometimes people look at pictures and it doesn't mean much to them. For a moment, it might have an impact, but our education system needs to be changed. Why is Palestine called occupied Palestine by the Israelis? They, by their own admission, it's occupied Palestine. It's not, that's not the name of the country. So education needs to take place in all the different languages. And each of us here come from a community. So we need to go back to the schools and to the universities and broader South Africa and Africa as well, and take back the message and educate people. Thank you.
And our last speaker who has the microphone. Yep.
Greetings to all. My name is Samira Piri. I have two questions to the panelists. The first one, does the judgment imply that the ICJ acknowledges that a genocide has occurred? And the second question, did the ICJ have power to declare a ceasefire? Some commentary suggests not, because Palestine is yet to be considered a fully fledged state. Thank you.
I'm not actually going to respond to the legal questions because I think those need to be responded to by the lawyers that were on the panel before me. But with respect to, I just want to say, you know, with respect to the civil society aspects of interconnectedness, we must remember Greta Thunberg was outside at the ICJ when the ruling was handed down, demonstrating how the environment is impacted by warfare, the costs of not only the economic costs as was discussed earlier, but the environmental costs. The fact that in the Palestinian context, there is also a rush for resources. There's also the implications of cheap labor coming from other countries in the global south to be used in the Palestinian context, and therefore erase the need for Palestinian labor in Israel proper. So I think that in terms of the way that this issue has been researched, there are many different aspects that have been highlighted in terms of how everything connects. I do think that one of the challenges we are confronted with is that there's a lot of information. And trying to process all of that information that comes in on a daily basis on social media makes it very difficult to target which specific issue you want to which specific issue needs to be prioritized in order to have then a ripple effect for liberation, right? But what I do take inspiration from is that civil society has also very organically transformed, and that's the whole point about movement building, is that as people start to feel more connected to a specific issue, and we are starting to see in many protests the linkage between the Sudan, Congo, Palestine, indigenous people in North America and Latin America, and how all of our struggles intersect. And I think what gives me a lot of hope is that this one issue is unifying people across barriers that ordinarily used to divide us. I think we're starting to see a resurgence of the global solidarity movement. No one needed to care about South Africa in the 1970s and 80s, and people started caring. And so I do think that we at every cycle in our humanity, we get to a point where we start to say enough, and it takes one issue for us to start remembering our humanity, and I do think this is one of those big issues. Thank you.
So in terms of the issue of the ICJ ruling, I'm not a lawyer, but from my understanding, the ruling said that there was a plausibility of genocide. That was the terminology, which means that there is plausible case, yeah. So a case to investigate. So yeah, the lawyers would answer this better. In terms of the issue of colonialism and, you know, all of the concern that we are focusing so much more on Palestine and perhaps not enough on the Congo and Sudan and so on. We need to have campaigns that bring together all of the, places where these challenges or the struggles are happening, because there's this phrase, people of the world unite, and that's what we really need to do, that we actually need to across the world come together. Palestine has united us in ways that we would never have imagined. So I think that on your concern about the Congo and so on, what we need to actually do is to keep those issues alive in the sort of, public space, because we have to actually make sure that those concerns are also going to be addressed. I mean, why is what's happening in Congo happening? Because of the, presence of, minerals and natural resources and so on. So the whole point about colonialism and imperialism, it continues. And we need to, as I said, try and find a way to unite so that we can undo and dismantle. We need to dismantle so much occupation, colonialism, and so on. And your point about Greta being at this thing, she is an example of the generation, this young generation that has changed. I mean, she sat outside, her school or every Friday. So that was radical. What we need to do is more radical things like that. And the young people are actually showing us the way. So I am really inspired by those kinds of things that the young people are doing. As for who to vote for, my sister, that's a complex one. As a political scientist, I get asked this question all the time. I would say, yes, let's vote for Gift of the Givers. But the point is that we need to vote for parties that advance human rights. And for me, at the end of the day, that is what will always inform my decision. If you support Israel as a party in this country, I cannot vote for you. So that's just my response. Thank you.
And I mentioned about Palestine in the beginning, it's about standing for humanity. But there's a time and a place. Sudan is battling, as the lady mentioned, Yemen, Somalia, Congo, the other places in Africa and Mali, in north. There's challenges between the government and the Tuareg people. So there's challenges all over the continent and other parts of the world. But in this kind of space, when you're pursuing a specific type of conflict or specific type of idea, you can't dissipate the energy. If you put 5 conflicts at the same time, nobody's going to follow anything. And the Palestine conflict has taken 75 years to bring it to the top of the table. It's taken a very, very long time. And it's the most difficult conflict because you're fighting at the most powerful forces in the world. And we succeed with that, and the youth coming and putting pressure on their governments and changing their government's ideas about imperialism and plundering resources. We may just bring about that changes for Congo or for other parts of the world. But we have to have one struggle that we all stand on strongly for to create the unity that she's talking about, with all the different groups standing together. So, we will get there as long as we don't forget, it's not about Palestine, it's about humanity. And of course, we need more buy-in from Africa. We need the African countries, the African people to stand out also. It's not, we sit back and watch the leaders do what they want to do. That's not acceptable. The people in the continent has to change. They have to make the difference. They have to show the initiative. It has to come from everybody. And we will get to that point. And again, we can use the media effectively on the African continents. Again, they have media that beams throughout the whole continent from one place like Nigeria. It's got channels that beams throughout the whole of Africa. Those can be the starting points. The same system we use for Palestine, the same system we can use for influencing media, social media, and all those kind of things. In terms of elections, she's giving you the answer. You've got to choose wisely, and it's your own personal choice. Thank you.
Please join me in thanking our panelists in this final discussion for their input. We are moving straight into Verlene bringing nice presents for our people. We're going to move straight into our closing session. I invite Dr. Pillay to join us on the stage to make her closing observations. You may get comfortable so you can watch her. Yes. We do. Okay. Okay, thank you.
Am I supposed to hand it over?
Yes, yeah. Me. Good. Good. Join it. We haven't given them to them yet.
Oh, you didn't get it.
Thank you so much. Taking a photo then.
I know, I'm stay out of picture. Yeah, to keep one of those bottles of water with you, yeah? If you don't mind opening.
Thanks a lot. Okay. Colleagues, it's fitting that this event, convened by the Navi Pillay Research Group at the University of KwaZulu-Natal, should be closed by Dr. Navi Pillay herself. She's our founding member, our mentor, our inspiration. She challenges and inspires us and works harder than all of us put together. She had COVID, people, just a few days ago. She is tested clear, but her commitment and her unwavering support and her energy and her passion for human rights and social justice just really inspire and motivate us. So before I hand over to Dr. Pillay, she is well known and loved as one of our own, a South African jurist who served as the United Nations High Commissioner for Human Rights from 2008 to 2014. She's a judge of the International Criminal Court. We've been speaking about the potential role in the future for the ICC. She was president of the International Criminal Tribunal for Rwanda, and importantly for the purposes of our discussion today in 2021, she was appointed as the chairperson of the United Nations Independent International Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem and Israel. Dr. Pillay, we look forward to your inputs and your observations on our deliberations today. Thank you very much.
Thank you, Janine, for that kind introduction, and thank you for staying behind. You know that the Commission of Inquiry, it's got a long name. We also shorten it. In fact, when we shortened it, you can't even pronounce the acronym. So try it yourself. So we opened the discussions at the first panel this morning, and I want to now bring it back there, because this is why we came to hear you. And of course, being a South African, I fully understand the calls for actions, the strategies that civil societies have in mind. Some even started campaigns for the one side or the other. Now, we are independent UN commissioners. We have to be impartial and not take sides. However, we made it very clear in our very first mandate, and this is because of so much pressure exerted on the Human Rights Council, that it is biased and is always battering Israel. That's what I was told when I was appointed UN High Commissioner for Human Rights as well. And so we set out in our very first report that we fully recognize that we are not dealing with two equal parties to a conflict. One is the occupier, the oppressor, and the other is the occupied, the oppressed. So there's no such thing as balancing. We know this is going on right now. 1,100 persons from Israel were killed or injured, and some others injured. And then comes the retaliation, which is now 26,000. So I'm fully aware that that's what they call balance. So we made very clear, we don't do that. We stick to the law, we stick to the facts. So in our first session, we gave you information about this commission, and I hope you all heard that. I could repeat it because it is very confusing. Who is who? In many interviews I gave, I don't blame people at all for confusing ICC, ICJ, is it the conference center here, ICC? Yeah, and then there's International Commission of Jurists, so they have the same acronyms. Now, I served as a judge on the International Criminal Court in the appeals section, and I'm still a judge, ad hoc, and that means just for one case, and that's the case brought by the Gambia against Myanmar. So I participated in that judgment where we granted provisional protection orders against Myanmar, and Myanmar is filing reports on that. I read them regularly. And the International Court of Justice is, as we've heard, a court that is accessible only to states. They do not prosecute anyone, and they do not have individuals before them. So it's not a criminal tribunal. It's rather a tribunal to resolve disputes between states and to give advisory opinions. So uniquely, that's where we are now, and South Africa is very much involved in one, bringing this complaint before the ICJ on the allegation of genocide. You'll notice that, you may be critical of that. We, the Commission, have not mentioned genocide as yet, but obviously we're fully aware, as we look at the circumstances, that these are all the indications. So we waited till a court pronounces it, and now we have that. In UN language, you really have to stick within your mandate, and Sun from our team explained to you our mandate and the various things we are required to do. So it mentions international law, Geneva Convention, human rights law, international humanitarian law, but not the Genocide Convention. But now we will readily address the issue and call it as such, genocide. Now, our purpose in coming to South Africa is we, the Commission, have gone to various countries, and it's been a great privilege to go to universities in particular, because we are indebted to academics for their knowledge and their research. They have the luxury, plenty of time to do research. So it's very, very useful for us. And of course, we are informed by the voices of civil societies, and in particular, youth and students. And since we have been to other countries, in fact, the very first meeting we called is of experts on the subject, international experts. And I was truly impressed about the number of them, including John Dugard, Professor John Dugard, who led the South African team before the ICJ. And we have, and of course, people like previous special rapporteurs, such as Michael Link, who first mentioned and put in our heads the thought about going for unlawful occupation. So there's a build-up of ideas, and when you're starting to do something for the first time, it's very important that you listen to everybody and you learn. And thereafter, we held oral hearings in Geneva. Well, before that, we were hosted by the King of Jordan and the Foreign Minister, which was really good because Egypt wouldn't let us use the Rafah Gate to enter Israel. Israel wouldn't let us in. They already had enough countries against this commission. The establishment of the commission by the Human Rights Council was supported by a majority of states, but still they did not include very many European states. So already that's the beginnings of the opposition to this commission, which was just to find the facts on the ground and report to the Human Rights Council and find out what are the root causes of the conflict. And as Sun explained, this is a very special commission because it doesn't have an end date, and it has a very wide mandate, and we can look inside Israel. Now that has never happened before. We asked Palestine if we can come and see the authorities there, and of course they were very happy if we do that, but Israel stopped us from doing that. Now even that is ridiculous. Yes, Palestine, recognized as a state organization by members of the General Assembly, and yet Israel has the power to decide who enters there and not. I know you're all familiar with Gaza being always described as almost a prison with no access and entry, but that is applying to Palestinian authorities as well. And this is why we approached Jordan, and it was such a pleasure to have both Israelis and Palestinians come out of Palestine and Israel through these borders. Some walked over and some flew. And they gave the evidence where we needed to protect identities. We did that. So you see what we were doing, step by step, hearing, consulting the people concerned. And then we've published 4 reports now. So let me mention the most important, which was in October 2022. And this is where we then explained to the General Assembly by setting out all the facts on the ground, setting out international law, it's a massive report, and having looked at every resolution passed by the General Assembly and Security Council relating to Palestine, every commission and special rapporteur's reports investigating this, and just now I'll tell you why you should admire our staff for having done those mountains of work. Having looked at all those facts, we then announced that the root cause of the conflict, which was our core mandate, what is the root cause of the conflict, and we said it's the occupation, and that it is now unlawful. It's unlawful because it's become perpetual, it's permanent, and because we were fully aware of the 2004 wall judgment before the ICJ. When it came to the question of the wall, the court made some key statements about roots being planted to perpetuate the occupation. And this is why we were very certain in our interpretation of the law. As Chris Sidoti said, we knew it's unlawful, but we're only a commission of inquiry, we're not a court of law, and we need the might of the General Assembly to ask the International Court of Justice to give its opinion. And that's the hearing that's going to happen on February 19th. So you have 2 cases to follow. The one which addresses the immediate issue, and the other to get to the root of the problem. And so we're here to hear opinions of South Africans on these matters, because we still have to continue doing our work. As I said, I'm still an ad hoc judge on that court, and I know what we said and ruled in the Myanmar matter. That is going on for 3 or up to 4 years now, so you should anticipate that South Africa's application is going to take very long on the final determination on the merit of whether genocide is being committed. So these meetings in various countries are very important for us. We've recently, last October, we were in the United States again, very many universities, very many public hearings. And after the discussions, people would come to us, I'm talking about now, after October 7th, that they're afraid to dissent. They're afraid to criticize Israel. So I want to say for my fellow commissioner and I, what pleasure and liberation it is for us to hear all of you speaking so freely on your issues. However, having heard the last panel and Imtiaz's video on the children, wonderful work that you were doing with the children, and all of which is crushed, reminds me of my visit to Israel as UN High Commissioner for Human Rights. You know, now, since I agreed to be chair of this commission, they are hurling all kinds of abuse against me and Chris Sidoti and the commission, that we're biased, we're anti-Semitic, and apparently I was biased even when I was High Commissioner for Human Rights, but they never said it then. It's all piling up now. It amounts to abuse, and we need your support to ensure that we are protected from this kind of abuse, because Unlike South African commissions, the UN does not pay its commissioners. It's entirely a service we do, and we like it that way. It shows our independence from the issues. However, since we were abused in the General Assembly by the Israeli ambassador, I decided we're going to make that public, which we did, made a huge storm of protest before the world press and wrote to the Security Council, the President of the General Assembly, and when we said, you created us, you want us to come and report to you, then make sure we have a safe place to report that. So I must say that this October that just passed, yes, so everybody behaved, especially that Israeli ambassador, no name calling. This is something I learned from South Africa. You speak up. Something's wrong, you speak up. You don't just keep it within you. So back to your video then, Imtiaz. As High Commissioner, I went to Seradot. That's the little town this side in Israel that is receiving all the rocket attacks from Hamas. And then you see their point of view. Their children cannot play outside. They're in bunkers day and night. They are terrified by the noise of these rockets falling. So lots of emotion. And yet when I went to the other side, saw the mayor of Gaza, there was total lack of sympathy for anybody else except themselves. Now, we don't want to fall into that trap. The message we received from these discussions is you care about humanity, reminding us of Mandela's message, never again, do not do to your oppressors what they did to us. So this is a wonderful, positive message that we South Africans have. So have empathy, sympathy for all victims, all civilians, wherever they come from. So Zosi, I recognize you, and if that's what you're teaching your students about humanity, and that we should care. Why is South Africa spending all this money bringing this application? The answer is we care. You know, we received overwhelming reaction from the global community to that application made by South Africa. It was almost like David fighting Goliath, a small country from the developing world, standing up for principles and human rights and all those conventions, treaties, and international laws that were mainly adopted by the West. Clearly, some of them think all those rules that they created are for Africa and the developing world and not for themselves. So now they have to apply it equally to all. We get the message in South Africa. It's really refreshing to be here. So that's one lesson I get from these discussions here. And we feel very encouraged by that. We're going to three or four other universities. We're going to be doing all that within 2 weeks. So by the way, back to humanity and caring, I get so often this question, you're so old now, why are you still running around doing these things? Shouldn't you retire and stay at home? Yes, so as long as you have a voice, as long as you can make a contribution, you do what you can. Now don't go into that situation of hopelessness. I hear so many young people saying, oh, it's our government, there's corruption, water, and so on, but they are giving up. We don't want that message. We stand and fight every step of the way. That's the way we got our freedom. That's the way we will continue. However, there are peoples in the world who have no such support. They're either in dictatorships or they're caught up in conflicts of long-term conflicts. And they need our help. And they feel psychologically very supported by actions taken by us. So that's the reason why Chris and I mean, you're not that much younger than me, Chris. Where's Chris at the back? Yeah. So this is why we continue to do what we're doing, because we can. And we can get your voices to very powerful fora. So we hope to engage like this in South Africa generally. And this has been a wonderful pleasure for us to have our first meeting hosted by the NPRG here. When we set this up, we didn't know how we could serve our students mainly. I hope that this reaches the students That's really our principal audience. I truly believe that fresh ideas come from young people. And they see no problem. You know, sometimes we hate them. They burnt the library, they burnt this building too, right? Yeah. I'm still a trustee of this university, and I know the repercussions after that fire. The donations just fell. However, the students had a point. They carried posters which said, "Do the poor not have the right to education?" So a profound human rights message. I spent a week at Al-Haq University in Palestine, just talking with students, and they really engage readily. I don't blame them, of course, but they're very, very bitter and negative, so they need some fresh outlook. They would not accept any criticism or, go easy on this or that. No, they wouldn't. And of course, they hated all governments, including their own. So I'm fully aware of how boiling campuses are. So our students need to help those students to reach out. How did we manage this? It was not easy, but we didn't get killed in the process. We survived in order to enjoy our freedom. So I don't know what else I wanted to say. I can see dark looks coming from my team. No? Yeah. All right, so let me say that when I was first sent by President Mandela to serve as a judge on the Rwanda tribunal in Arusha, like the first 3 years, all I did was complain and complain. There was no water, no power, dirt roads, no pasteurized milk. It was just no supermarket, no banks. So we were paid in shoeboxes full of banknotes, $100 banknotes, some of which were fake, and nothing you can do. There's no bank for you to exchange that. So you see, we did have a lot of complaints, and I was the key person complaining about the mosquitoes, the malaria, until we started hearing the witnesses. And then you think, what exactly are you complaining about? You're getting paid to do this job? These people are getting nothing, and they're reliving the whole genocide by coming and telling the world. And they said to us judges, we waited for this day to see justice being done. So it's not about us each time, it's about them, caring for them. So I had to learn myself as I took every step. So I find that I should share with you some of the obstacles in our way, that it's so unfair. And then you will understand how fractious and double-standard Western states are towards developing countries or projects that they do not support. So in our case, the Human Rights Council established this commission. Its legal status is that we, the Commission, are a subsidiary body of the General Assembly. That's why we report to them, we're accountable to them. And the General Assembly, in its various committees, is in charge of allocating our funding. So the Deputy High Commissioner in Geneva motivated a budget of, I might just get the figures wrong, Giuseppe, but at that time, I think she said 24 staff, and about 14,000, the budget, 14 million.
7 million per year.
All right, so she asked for 7 million a year. And you won't be surprised, I went and fought with the Deputy High Commissioner first to say why so little. But then we don't even get what we asked for. The budget, the amount was cut to 4 million. The staff, they just slashed 1/3 off. And in the US Congress, the Republican senators who support Israel, they seem to be the majority, were really praising themselves for having cut our budget down. And you have to then wonder what kind of multilateral institution is this, where states who don't support certain commissions can cripple that commission. And that's what I meant by the reduced staff we have, and yet we have such a huge mandate. And I noticed that for instance, the IIIM mechanism for Syria. Remember that the coalition forces and the US, they bombed Syria to bits, yeah. And this is to investigate, collect evidence, and so on. The General Assembly established that mechanism, gave them 80 staff, yes, yeah, Giuseppe is nodding, and 80 million rand a year. So I give you that comparison of the importance of our work, and all they're doing is one aspect of our work, which is gathering and collecting evidence. So it's very, very hard in these formal membership fora to argue principles of equality and fairness. They just have the power of the vote, and they rule that. And in the US Congress again, the Republicans ordered Blinken to go and disband that Pillay Commission with so little understanding that this is an international body. They have no power. Aren't we happy they don't have that power? Yeah, to interfere to that extent. But these are the kind of resolutions that are being adopted there. And so I'm really appalled that a resolution from the General Assembly following our recommendation of referral, get an advisory opinion from the International Court of Justice, their own court, was opposed by the United States, Europe, UK. We went to Europe, we asked some of the member states' representatives, and they said, well, this interferes with the peace process. We wanted the status quo to remain. And that's why I agree with Chris Sidoti that we predict that would be the kind of arguments that will be raised on February 19th by very many states who have rushed to file their own briefs. They were allowed to file their own position papers against what we've recommended, which is declare the root cause declare the occupation as unlawful, because it's in perpetuity, and secondly, spell out the responsibilities of states. And between you and me, that scares them, that second one, because, you know, Max and others spelled out to us what's the legal consequences. There are already decisions of the ICJ. I think Max said in the Namibia case, or Chris told us, it's a Namibia case, about the responsibilities of states in supporting anything that is deemed unlawful. So I just wanted to stress with you that the small team we have has managed to do all that and get this matter before the ICJ. So I ask you for your support, both moral and political, and your support in particular to ensure that we are enabled to do our work and not subjected to abuse. You know, I personally thought I'll get some voice from my government to say, that's wrong, you know, she's helping there and she shouldn't be abused. She's also old. Yes, she deserves some respect. This is not me quoting. Quite a few NGOs said, yeah, you know, she's 80 years old now. They should treat her with respect. But that's not the point. We're doing UN work, and that's the work that should be respected. So thank you again, all the speakers. They were really excellent, making excellent contributions. And thank you to the academics, staff, and students here at the university for providing this opportunity for us. Thank you again.
I want to thank you all for joining us and being with us for this day. I have to thank colleagues from the Navi Pillay Research Group and colleagues within the School of Law for their support in organizing and making today happen. Christopher Reddy, the brainchild who conceptualized the program, and with his network of formidable contacts and activists and actors in this space, put this program together. So really, thank you, Christopher, for doing this. And my colleagues, Professor Valine Holness, Dr. Sheetal, Matthew, Simone is still here, Nomfundo, who assisted us, Carol in mobilizing and in making things happen at our various reservations, our booking, Hazel Lange and Norma from our corporate relations, Carl and your team for being with us the whole day and putting the technical support together. Colleagues, thank you so much for your support and being with us. We would like to invite you to join us. There's some refreshments outside. We can continue those conversations, but otherwise, warm wishes to you all. Safe travels home to our guest speakers. Thank you for flying in and being with us today. It was really wonderful having this day with you. Thank you.